ನಾವು ಯಾವ್ದಾದ್ರು ಕೊಟ್ಬಿಟ್ರೆ ಈ ಡೇಟ್ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ ಮಿಕ್ಸ್ ಆಗ್ಬಿಡುತ್ತೆ ಅಂತ ಅವರು ಸರಿ ಬರ್ಕೊಟ್ಬಿಡಮ್ಮ ಬರ್ಕೊಟ್ಬಿಟ್ಟು ತರ್ಸ್ಕೊಳ ಚಲ್ ಸರ್ ಹೇಳಿ ಸ್ಫೂರ್ತಿ ಅವರು ಗೊತ್ತಾಯ್ತು ಅಲ್ಲಿ ಕೇಳಿದ್ರ ಯಾಕೆ ಪೋಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಅಲ್ಲಿ ಒಂದ್ಸಲ ಕೇಳ್ರಿ
Kotal 12. Shripad sir. Kotal 12.
ಕೇಳ್ತಾ ಇದೆ
Sir, video clear ಇದೆ ಅಲ್ಲ?
ಕ್ಲಿಯರ್ ಇದೆ
Okay sir, thank you sir.
ಸರ್ ಟೋಟಲ್ 12 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಓಕೆ ಸರ್, ಓಕೆ.
Number 2 file ಅಲ್ಲಿ ಮೂರ್ ಫೈಲ್ ಅಷ್ಟೇ ಫೈಲಿಂಗ್.
Court officer. Court officer.
ಹಲೋ, ಹಾ ಮೇಡಮ್ ಹೇಳಿ.
ಸರ್ MS ಬಸವರಾಜು ಅಂತ ಇದಾರ ಸರ್ ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್. ಅವ್ರದ್ದು ಒಂದ್ ಸ್ವಲ್ಪ ಫೋನ್ ನಂಬರ್ ಶೇರ್ ಮಾಡಕ್ ಹೇಳಿ ಸರ್ ಅವ್ರಿಗೆ.
ಬಸವರಾಜು ಅಂತ ಅಡ್ವೊಕೇಟ್ ಇದ್ದೀರಾ ಇಲ್ಲಿ?
ಮೇಡಮ್ ಸದ್ಯಕ್ಕೆ ಇಲ್ಲಮ್ಮ ಕೋರ್ಟಲ್ ಅಲ್ಲಿ.
ಓಕೆ ಸರ್,
ಕಂಡ್ರೆ ಹೇಳ್ತೀನಿ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಇಪ್ಪತ್ತೇಳನೇ ಬಂದಿದ್ರೆ 27 ಲಿಸ್ಟಿನ ಮಾತ್ರ ನಂಬರ್ ಸಿಟ್ಟಿಂಗ್. ಈಗಲೇ ಮಾಡ್ತೀವಿ.
Tomorrow.
For page wise adjournment, list number 2, page number 1, serial number 1 and 2, page number 2, serial number 3 to 8, page number 3, serial number 9 to 30, Page number 4, serial number 14 to 19. Page number 5, serial number 20 to 26.
21. Yes, Mr. Sabin may be called along with the so and so next week.
Page number 6, serial number 27 to 31. Page number 7, serial number 32 to 35. Page number 8, serial number 36 to 42.
Yes. Office is directed to secure original records from the tribunal.
Page number 9, serial number 43 to 50.
Office is directed.
41, I object for the adjournment, my lord.
You are appearing for
41, my lord, I appear for the appellant, my lord.
49. 49. Yes. 49. Secure records. Serial number?
Page number also.
For the request of counsel for the appellant, release this matter of 2 weeks.
Page number 10, serial number 51 to 56.
As named, yes, the net counsel for the appellant has yes, filed a memo seeking leave of this court to withdraw this writ appeal. Memo is taken on record. The appeal is dismissed as withdrawn.
Page number 11, serial number 57 to 62. Page number 12, serial number 63 to 69. Page number 13, serial number 70 and 71. Number 13 matter, page number 3, page number 1, serial number 1 to 3. Page number 1, hearing interlocutory application matter, serial number 1 to 10.
Notice.
Admission matter, 11 to 18.
Notice.
List number 2. Order, serial number 1, this is given in the appellant.
Yes. Memo for withdrawal of the deposit amount filed by. Yes. Records has come. Yes. No, but memo for withdrawal is not maintainable now. Now there is a circular. IA and affidavit has to be filed. Yes. If file an IA, I will dismiss this memo. Yes, yes, that is there. Yes. Memo for withdrawal of that amount is dismissed as not trust. Yes. Next week. Yes, release this matter next week. No, that it is a workman compensation. What is the substantial question of law? Yes, sir. Substantial question of law. That is the only a question of law we have. Yes. Admit the substantial question of law arises for consideration whether court will have justified held that the claimant has proved the relationship of master and servant between claimants and fifth respondent. We will this matter next week. Yes.
Number 2, Raju for appellant, H.S. Lingaraj.
I appear for the respondent.
Yes.
ಇದು claim petition dismiss ಆಗಿದೆ on the ground that it is a case of self negligence. LCR was called for.
Yes. Records will wait. 163A.
ಹೌದು 163A ಆದ್ರೂನು
Your own vehicle.
ಅಲ್ಲಲ್ಲ ಬಾರೋಡ್ ವೆಹಿಕಲ್ ಅದು ಪಾಲಿಸಿ ಇಲ್ಲ ನನ್ನ ಹತ್ರ. ಅದೇನೋ ಪಾಲಿಸಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೆ ನನ್ನ ಹತ್ರ ಏನಿಲ್ಲ ನನ್ನ ರೆಕಾರ್ಡ್ಸ್. ಅದಕ್ಕೆ ಪಾಲಿಸಿ ಏನ್ ಕವರೇಜ್ ಇದೆ ಅಂತ ನೋಡ್ಬೇಕಿತ್ತು PA ಕವರ್ಗೆ.
Yes, you have that policy. Given a copy to him. Next week, you give that copy. Yes. Finish this matter next week.
Serial number 3, Pundika Ishwara Bhatt for appellant, Geeta Raj.
Yes. Memo for dispensation of notice to R1 is dispensed. Delay of 51 days in filing an appeal is condoned. IA 1 of 2019 is allowed. Yes, where is Geeta Raj? What is that, Mr.? Only quantum. The enhancement, liability dispute illa. Where is your opponent? Asor.
Kavita HC for appellant. Ravi Shankar here.
Notice to R1 is dispensed. Ravi Shankar, yes, next week. Huh? Where is Ravi Shankar? Next week.
Number 5, Sanjay D for appellant, YK Chetty Rao.
I appear for the appellant, my lords.
Yes.
Claimant's appeal, my lords, there is 163 days delay.
Ready, Mr.
And, connected matter on this, 7154 of 19. There are same common judgment ಇದೆ. ಎರಡು connect ಮಾಡಿದ್ರೆ next week ready.
Notice to R1 is dispensed. 163 days delay is controlled, not entitled for the interest. The net counsel for the appellant submits that this appeal may be called along with the phone.
Divakar PS for appellant.
Much.
Week's time is granted to do the needful.
Serial number 7, R. Jadidhara for appellant, United India.
United India are there, yeah. Ready. Notice to R1 is dispensed. Delay of 76 days in filing an appeal is condoned. R2 is served unrepresented. Shankar Reddy is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies. Yes.
Number 8, R. Jadidhara for appellant, Muralidhara N.
Muralidhar, necessary. Notice to R1 is dispensed. Office is directed to secure original records from the tribunal.
Serial number 9, Raghu R for appellant, United India.
Notice to R1. Notice to R1 is dispensed. R2 is served unrepresented. Shankar Reddy is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies.
Application
Post ಆಗಿಲ್ವಾ? Yes, for delay of 480 days condoned, not entitled for the interest. Of the request of the parties, refer the matter to local.
Serial number 10, FS Sabali for appellant, Abhijit N.
Non-depositing 50% award amount. You have deposited 50,000. Why you have challenged, Mr.? Allah, 50,000 rupees for 50,000 you have filed an appeal. Your what is that? Dismiss it, confirming that liability and challenge madila. Tara? Yes. Towards the medical expenses due to the accident injury, she is unable to do any work prior to that accident. She was fully working 10,000 per month. And so, awesome, but the exhibit silent about her admission ends that contention that petitioner about she has taken treatment as an inpatient cannot be accepted. Produced order to sustain about pending an amount of 50 towards the medical expense. What is that document they have produced? Injury certificate, exhibit P7, doesn't show that she has sustained pain, tenderness. Liability any last time. I will consider your contention. I was ₹50,000 what is that? What is that interest awarded? 6%. Exhibit P7 ಇದೆಯಾ? It goes to show that she has sustained pain and tenderness over the chest, abrasion in the upper lip, laceration over the lip, tenderness below the chest. Istella injury ಇದೆ. Left ankle and tenderness. Overall said that injuries are simple in nature as per the opinion of the doctor, even though the petitioner has contended that she has. Yes. Yes, I will consider that. I will consider that 50,000 is ಅಲ್ಲ ಅವೆಲ್ಲ ಜಾಸ್ತಿ ಇದಾವೆ. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಎಲ್ಲ ಗ್ಲೋಬಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಯಾವ್ದೋ 4,50,000 ಎಲ್ಲ ಇದೆ. ಅದೊಂದ್ ಬಿಟ್ಟು ಬಾಕಿದ್ದು ಎಲ್ಲ ಮುಗಿಸ್ಬಿಡೋಣ. ಎಸ್, ಯಾವ್ಯಾವ ಕನೆಕ್ಟೆಡ್ ಇದೆ ಕೊಡಿ. ಕೊಟ್ಟಿದ್ದೀರಾ? ನೀವು ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ? You have filed an appeal challenging that enhancement. Ask him whether there is any cross appeal against this. 50,000 ರೂಪಾಯಿ 50,000 ರೂಪಾಯಿ ಕ್ರಾಸ್ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರೇನ್ರಿ? ಅವ್ರು 50,000 ರೂಪಾಯಿ ಜಾಸ್ತಿ ಅಂತಿದ್ದಾರೆ. ಆಯ್ತು, ಆ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಮಿಸ್ಟರ್ ದಬಲಿ? ಎಸ್. Learned counsel for the appellant has sufficient that this appeal may be called along with that shown. ಅದ್ರಲ್ಲಿ ಇದೆಯಂತ ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
Number 11, Sripal B. Shastri for appellant, L. Srikant Rao.
For appellant, my lord.
Yes, Srikant Rao. Ready?
Respond.
ಇದು LL ಇದೆ ಆದ್ರೆ LL ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಹಾಕಿದ್ರು, ಅವ್ನು ಪ್ಲೀಡ್ ಗಿಲ್ಟಿ ಮಾಡಿದ್ದಾನೆ ಅಂತ ಹೇಳಿ ಕಂಪನಿ ನಾಟ್ ಲಯಬಲ್ ಮಾಡಿದ್ದಾರೆ. ಇದು as well as enhancement is concerned, marginal enhancement, my lord. There is no such this one doctor not examined.
Where is that LLR? Is it a
LLR is produced and duly marked. It is found in page number page number 3, para number 3.
What is that vehicle, mister?
It is a car, my lord. It's a car.
ಕಾರ್ ಮತ್ತೆ LLR ಅಂತಂದ್ರೆ ಪೇಂಟ್ ರಿಕವರಿ
ಮಾಡಿ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಕೊಟ್ಟಿರೋದು 50,000.
ಇಲ್ಲ 50 ಅಲ್ಲ 93,000 paid. 93,000.
Insured was duly represented before the tribunal.
ಹೌದು, ಅದೊಂದು ಹೌದು. ಅದ್ರಲ್ಲಿ R1 is the driver. ನಾ 2 ಜನರಿಗೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ತಗೊಂಡಿದ್ದೇನೆ. All the liability is already foisted on the owner of the vehicle. Since dispensation does not make any difference, that is why, my lord, as per the judgment of this court,
yes, mister,
ಅಲ್ಲ ಅವರಿಗೇನು ಇದಿಲ್ಲ.
ಪೇಂಟ್ ರಿಕವರಿ
ಅಲ್ಲ, ಡಿಸ್ಪೆನ್ಸೇಷನ್
ಅಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಟೆಕ್ನಿಕಾಲಿಟಿ ಮೇಲೆ ಹೋಗ್ಬೇಡಿ.
ಲಯಬಿಲಿಟಿ ಇಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅಲ್ಲ, ಸರ್ ನಾನು ಹೇಳ್ತೀನಿ, ಲಾ ಪ್ರಕಾರ ಲೀಗಲ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Srikant Rao, now that recent judgment, even in the appeal filed by that owner, paint recovery can be passed. That is what that this court held.
ಹೌದು,
Even owner appeal.
I did.
That is recently, last 2 weeks, there is a judgment. Yes.
I saw it.
Yes. That is the only point. Yes.
only point. And loss of earning for the laid up period 9,000 ತಕೊಂಡು 1 ತಿಂಗಳ ಮಾಡಿದ್ದಾರೆ. ಅದು 3 ತಿಂಗಳ ಮಾಡಬಹುದು.
ಅಲ್ಲ, ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಇದೆ.
ಹೌದು ಸರ್, ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಇದ್ದು, ಲಯಬಿಲಿಟಿ ಇದೆ.
No, Mr. Shastri.
Yes, my lord.
You are only stick on to that paint recovery.
ಆಯ್ತು ಸರ್, ಮಾಡಿ ಸರ್.
Otherwise, I have to secure records because.
ಬೇಡ ಮತ್ತೆ ಬಿದ್ಕ ಇರೋದು ಬೇಡ ಸರ್.
Yes, tell. Notice to R1 and R2 is dispensed. Shastri, learned counsel appearing for the claimant has contended that as on the date of the accident, driver of the offending vehicle was having LLR. Since he was not having any valid driving license, the tribunal has passed on the liability on the owner of the offending vehicle. He contended that since offending vehicle is insured with valid insurance policy in respect of claimant is concerned, the insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. In support of his contention, he has relied on judgment of apex court in case of Koppu and full bench of this court, and also judgment of Sanjay Gupta judgment. What are the pain recovery? Last time hence he sought for allowing that appeal. For contra, Sri Control Learned Counsel appearing for the insurance company has contended that it is not in dispute as on the date of the accident, driver of the offending vehicle was not having valid and effective driving license. Since insured has violated the policy condition, the insurance company is not liable to pay that compensation. The tribunal has rightly exonerated the insurance company. Hence, he sought for dismissal of the appeal. Or the learned counsel for the parties arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 23/12/2017 due to rash and negligent driving of driver of Swift Desire car bearing registration number KA13 N5424. The only question that arises for consideration in this appeal, whether the insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. In this case, it is not in dispute that driver of the offending vehicle was not having valid and effective driving license. Since insured has violated the policy condition, the tribunal has rightly exonerated that insurance company from liability. Since the offending vehicle was covered with valid insurance policy in respect of claimant is concerned, the insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle. Accordingly, the appeal is allowed. In part, judgment and award passed by the tribunal is modified as follows. That the insurance company is directed to deposit entire compensation amount with interest within 6 weeks from date of receipt of copy of this order with liberty to recover from owner of the offending vehicle. Notice to R1 is dispensed. Delay is controlled, but the request refer the matter to local Adalat. Notice to R1 is dispensed. Delay is condoned, but the request refer the matter to local Adalat. Reliance yaar idhar Patil. Yes. Notice to R1 is dispensed. Delay of 153 days 6 condoned, not entitled for the interest. R2 is served 100% time. Patil is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies. Please this matter next week. Yes, Mr. Have you deposited that amount? Yes, it is a case of death. What, on what ground you are? Huh? Yes, sir, the request of counsel for the appellant. Release this matter of 2 weeks.
Pages sent for appellant, Excellency Keshava Prashant.
I appear for the respondent's case.
Ready, Mr. Keshav?
Blood records ಬೇಕಾಗುತ್ತೆ ಅನ್ಸುತ್ತೆ.
Yes, notice to R1 is dispensed. Office is directed to secure original records from the tribunal.
Bill number 70, pages sent for appellant, EA Sanmati.
Ready? Yes, notice to R1 is dispensed. Yes. Two 2019. Yes. Fourteen days. ಏನ್ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್? What is that disability assessed by the tribunal? Kandidaara? There is no dispute regarding that. 23%. Income? $7,000 ಕೊಟ್ಟಿದ್ದಾರಾ? How many days you are in that hospital? Income correct ಇದೆಯಾ? ಕಂಡಿದ್ದಾರೆ. On the other hand, loss of future income ಆಯ್ತು. Pain and suffering 50 ಕೊಟ್ಟಿದ್ದಾರೆ. Conveyances 50, medical expenses, loss of amenities 50, loss of income during the later period 7,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Yes, future medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ. That will make it 3 months and dispose of. You are taking that future not medical expenses, future prospects.
In case of 100% disability or unspecific granted, here the factors are united. Page number 11 of the judgment in the middle of the paragraph. The cause examination, he admits that the factors of the petitioner are united.
Where is that?
Internal page number 11.
What is he?
Yes, sustained fracture of type 3C.
What is he? What is working? Have you proved that?
The employer is not examined. What income has been taken?
Have you proved that you have removed from the service?
No, it's not.
That has not been.
Author of the document is not examined.
Then we'll secure the records. We'll see.
He has not examined admittedly.
Then see, if you have proved that you have removed from the service, then we can consider that it will affect your this thing. But tribunal has taken that notional income. That would be the
Factors are united as per the obligation of admission. Sufficiently recorded in the
Huh?
record of-
yes, we'll consider in the evidence. Where is that you are working in that company? No documents has been produced. He has given letter that you have been removed. Where is that document to show that you are working? Where is that salary certificate?
Well, nothing has been produced, but only.
And he has not been examined.
He has not been examined.
Yes. Right. We'll consider in other heads. Yes. See, Tejas Lugnet Council appearing for the climate has contended that at the time of the accident, he was working Sri Mahadeshwari offset printer and he was earning 25,000 per month. Due to that accidental injury, he has been removed from the service. The tribunal has not granted any compensation for future prospects. He contended that due to that extent, the claimant has suffered grievous injury. He was inpatient for a period of 14 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Shri Karmati Learned Counsel appearing for the insurance company has contended that even though the claimant has produced exhibit P6 to show that he was working in Mahadeshwari offset printer, he is not producing any document to show that he has produced exhibit P16. The letter issued by the proprietor, Sri Mahadeshwari offset printer, that he has been removed from the service. He has not produced any document to show that he was working in that printing shop. And he has not produced salary certificate. And he has not examined that employer to prove that he was working in Mahadeshwari offset printer. The tribunal, after considering that the evidence of the parties, has rightly held that the claimant has failed to prove that he was working in printing press, and rightly has taken the notional income. Since the injuries are minor in nature, the fractures are reunited. The tribunal has rightly not granted any compensation for future prospects. That our very future prospects. He further contended that considering that injury suffered by the claimant, considering that evidence of doctor, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Or the learned counsel for the parties, thereof, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 7/4/2019 due to rash and negligent driving of rider of bike bearing registration number KA 42 U5982. Due to that accident, the claimant has suffered the following injury. Even though the claimant has produced exhibit P16, letter issued by proprietor of Sri Mahadeshwara offset printer, he was not examined the employer, and he has not produced any salary slip showing that he was working in a printing press. Therefore, the tribunal has rightly assessed the notional income of the claimant. And since he was failed to prove that he was working in the printing press, and injury suffered by the claimant will not affect his avocation, the tribunal has rightly not granted any compensation under the future prospects. Considering that evidence of doctor, the tribunal has rightly assessed the whole body disabilities, and the compensation awarded by the tribunal for loss of future earning is just and reasonable. Due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 14 days. He has suffered a lot of pain during the treatment. He has suffered the disability and unhappiness throughout his life. Considering that evidence of doctor, injury suffered by the claimant, I'm inclined to enhance the compensation for pain and suffering from 50,000 to 75,000. Loss of immunities from 50,000 to 60,000. Loss of income during the later period for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. Enhanced compensation amount carries 6% interest.
The interlocutory application matter, serial number 18, Mr. Kamath for appellant, P.B. Raju.
Mr. Kamath,
Serial number 18,
yes, Mr. Mustaq Ahmad. Yes, madam. Huh? Yes. Yes, delay. Yes. Delay of 141 days in filing an appeal is condoned. Yes, what is that on merit? Is there any dispute regarding the liability? Where is Raju? Yes, delay condoned next week.
serial number 19, P. Pradeep for appellant, P. Satish.
Yes, Pradeep, what is it? PA coverage ilva? Injury case al baralla PA coverage. Then Mr. Yes, delay of 4 days in filing an appeal is condoned. Have you deposited that amount? Okay. Next week. Delay condoned.
Serial number 20, Suresh M. Lathur for appellant, IFCO Tokyo General Insurance.
Court okay, yaridare. Court okay, Pradeep, you are there. Yes. Delay of 2 days in filing an appeal is condoned. R2 is served unrepresented. D. Pradeep is directed to take notice. Learned counsel for the appellant is directed to serve 1 set of copies. Copy code here.
Serial number 21, adjourned. Serial number 22, K.P. Bhuvan for appellant, L. Srikanta Rao.
I prefer second response. Second response.
347 days, 41 days. 41 days delay is condoned. Ready now, Srikant Rao? Yes, ready. You are ready, Mr.
Ready, sir.
Yes, Mr. What is 1-5? Yes. Which is that MUC?
40,
4112.
4012.
4012. Where is that? In which page is the discussion?
Para 11, Dr.
11. Yes. 21% whole body disability stated by the doctor appears to be in higher side. Measure of body so 12%. What is that? Left limb 12%, 42%. Left lower limb.
1/3 ಆದ್ರೆ 13%.
13%, 12% ತಗೊಂಡಿದ್ದಾರೆ. ಆಯ್ತು. 2%. What is that income?
Income 8,000 ತಗೊಂಡಿದ್ದಾರೆ, 11,000 ತಗೋಬೇಕಾಗುತ್ತೆ.
8,000 ತಗೊಂಡಿದ್ದಾರೆ. Yes. What are the injuries, Mr.?
Fracture of both bones of left leg, right foot first toe.
Pain and suffering. What is the date of the accident? 2017.
See 10/6/17. 11,000 ತಗೋಬೇಕಾಗುತ್ತೆ.
Loss of income during the later period. Loss of future earnings. Loss of immunity. Future medical. That's all. Yes, Mr. Yes.
ಅದೇ 11,000 ತಗೊಂಡು ಮಾಡ್ಬೋದು.
Future medical
ಡಿಸಬಿಲಿಟಿ 12% ಮೇಂಟೈನ್ ಮಾಡ್ಕೊಳ್ಳಿ.
25 ಕೇಳಿದ್ದಾರೆ, 20 ಕೊಟ್ಟಿದ್ದಾರೆ. ಶ್ರೀ Bhuvan, Learned Council appearing.
It will not carry interest, future medical expense.
No.
Future
The future
medical
medical expenses that is there.
ಆದ್ರೂ ಕೊಟ್ಬಿಡ್ತಾರೆ.
We are not enhancing. That will be retained as it is.
ಆಯ್ತು.
Learned Council for the climate has contended that at the time of the accident, the climate was earning 35,000 per month. The tribunal has assessed the notional income of the claimant as 8,000 per month is on lower side. He further contended that due to the accident, the claimant has suffered grievous injury. He has examined the doctor as PW3. In his evidence, he has deposed that the claimant has suffered 42% disability to left lower limb and 21% to whole body. The tribunal has assessed the whole body disabilities, 12% is on lower side. He further contended that due to the accident, the claimant has suffered grievous injury. He was inpatient for a period of 15 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, L. Shrikant Rao, Learned Council appearing for insurance company, has contended that even though the claimant has claimed that it was earning 35,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed notional income of the claimant as 8,000 per month. He further contended that considering that evidence of doctor and injury suffered by the claimant and considering that wound certificate and discharge summary, the tribunal has rightly assessed the whole body disabilities 12%. Lastly, he has contended that considering that evidence of doctor injury suffered by the claimant, the compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is just and reasonable. The interest awarded by the tribunal, 8% is on higher side. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 10/6/2017 due to rash and negligent driving of driver of car bearing car bearing registration number KA43 M7184. Due to that accident, the claimant has suffered the following injury. He has examined the doctor as PW3. In his evidence, he has deposed that the claimant has suffered 42% disability to left lower limb, 21% to whole body. Considering that the evidence of Dr. Somsekhar, PW3, and considering that wound certificate exhibit P5, discharge summary exhibit P9, I am of the opinion that the whole body disabilities can be assessed 14%. Even though the claimant has claimed that he was earning 35,000 per month, he has not produced any document to establish the same. Under that circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority for the accident occurring 2017. The notional income has to be considered as 11,000. At the time of the accident, he was aged about 26 years. The multiplier applicable to the TH group is
17.
17. Accordingly, loss of future earning has been reassessed as follows. 15, 14. Due to the accident, the claimant has suffered the above said injury. He was inpatient for a period of 15 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, 14, considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of amenities from 20,000 to 35,000. Loss of income during the later period for 3 months. The compensation awarded by the tribunal, in the other hand, are just and reasonable. Enhanced compensation amount carries 6% interest.
But
Sak. Yes.
23, for appellant, B.R. Sundar Rajagupta, P.B. Raju.
Yes. Who is appearing? P.B. Raju. Pass on. Yes, Raju.
P.B. Raju.
Pass on.
24, Sanat Kumar Jain for appellant, Subhash Srinivas Rangachar.
Yes. Subhash Srinivas Rangachar. Yes, Mr. Oh, Subhash, you are there. Yes. Yes. Yeni.
Has given the evidence. Yes, told the vehicle is responsible. But there is no document that that has been transferred. Asking still in the name of the responsible person. Therefore, I am challenging the person to liability and responsible one as well as the liability.
Now that respondent number 2 is served unrepresented, then rule has to be issued. That now, what about that delay? You can condone the delay, Mr. Subhash.
I leave to the court, man.
Yes, there is a delay of 948 days in filing an appeal. Heard the learned counsel for the parties. For the reasons stated in the accompanying affidavit, delay of 948 days in filing an appeal is condoned. IA 1 of 2019 is allowed subject to condition. Appellant is not entitled for the interest. Or issue rule. Or admit. Yes, if it is admit, the records will come. Yes.
Tata AIG General Insurance.
Tata AIG ಯಾರಿದ್ದಾರೆ? You are there, Shivan Gowda? Yes.
For the appellant.
Yes. Notice delay of 845 days in filing an appeal is condoned, not entitled for the interest. Respondent number 2 is served unrepresented. Shivana Gowda is directed to take notice. Yes, next week, case of death.
Taking the next week, my lord, it's only this. My lord, the
Yes.
entire burden added upon the owner, my lord, instead of the insurer.
Why?
But the breach of policy conditions, my lord, the driver doesn't possess the license while driving the vehicle. That is only the may be taken up in the next week, my lord.
Copy ಕೊಡ್ಬೇಕು ನೀವು ಅವರಿಗೆ.
I will today. I will serve, my lord. It may be taken.
Yes, Shivana Gowda. Yes.
Please.
Basavaraju MS for appellant, Mohammed Umar Farooq, Harini Shivananda.
Yes.
I appear for the respondent.
Basuraj MS. Who is that Basuraj? Is it a claimant appeal?
ಹೌದು ಸ್ವಾಮಿ, ಕ್ಲೈಮೆಂಟ್ಸ್ ಅಪೀಲ್.
You will condone the delay and we will post this next week. Let us.
ಅಲ್ಲ, ಇದನ್ನ ಲೋಕದಲ್ಲಿ ಕಳಿಸ್ಬೋದು ಅನ್ಸುತ್ತೆ.
ಅವರೇ ಇಲ್ಲಲ್ಲ. Unless he agreed, how can I?
ಆಯ್ತು ಸ್ವಾಮಿ.
Basuraj, none appears. Release this matter next week. Let us see.
Number 27, S.C. Richabhendraya for appellant, Suyog, Herale E, 13 years.
Yes. What is this, Mr. Liability? Records beka? 38 days delay is condoned. Year 1 of 2019 is allowed. Office is directed to secure original records from the tribunal. Copy ಕೊಡ್ರಿ ಅವರಿಗೆ. ಕೊಡಿ ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. ಆಯ್ತು ಕೊಡಿ ಅವ್ರಿಗೆ.
Kantaraj came for appellant, Geeta Raj, Shankar Reddy.
Yes. Who is appearing? Delay of 271 days. Yes, Geeta Raj. Delay of 271 days is condoned, not entitled for the interest. Next week, yes.
Number 29, Ravishankar Shastri Ji for appellant, A. Ravishankar.
Yes. Delay of 6 days condoned. Ready? Records. Office is directed. Yes, the office is directed to secure original records from the tribunal.
Number 30, Pawan Chandra Shetty X for appellant.
371 days in filing note certificate copies of the award produced in this appeal doesn't pertains to that challenging that MEC. However, award is not necessary as per the order dated so and so. Yes. Notice. Yes. You want to dispense? Yes, notice. You file it in the office.
31, Girish B. Paladare for appellant, Radha BP.
3 days delay condoned. Ready? Yes. 15 years. Yes. Hmm. 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 Hmm.
The report from the neurological assessment report. The opinion of the report.
What happened, Rani? Connie?
Just in scale IQ of 84, it falls under the category of normal level of intellectual ability. Intellectual ability has been reduced from the neurological assessment report of issued by the competent authority of finance.
Where is the discussion of the tribunal?
Has discussed the entire issue.
Physical exam in PWA. Yes. Examination petitioner noticed that the area in which the operation was conducted has become a successful discharging the petitioner and he has no practice also. Absence of any injury victim had suffered any permanent disability. What is that evidence of the doctor regarding the disability? Huh? Hospital 2 ವರ್ಷದಿಂದ ತಗೊಂಡು 6 ಗಂಟೆಗೆ ತುರ್ತು ಚಿಕಿತ್ಸೆಗೆ ಬಂದಿರ್ತಾನೆ. ಇಲ್ಲಿ ಪರೀಕ್ಷೆ ಚಿಕಿತ್ಸೆ ಮಾಡಿಸಿ ದಾಖಲೆಗಳಲ್ಲಿ ಚಿಕಿತ್ಸೆಗಳು ಮುಂದುವರಿಸಲಾಯಿತು. ಗಾಯಾಳುವಿಗೆ ಔಷಧಿಯನ್ನು ಪ್ರಾರಂಭಿಸಿ ಐಸಿಪಿ ಮತ್ತೊಮ್ಮೆ ಸ್ಕ್ಯಾನ್ ಒಳಪಡಿಸಿ ಇದಾಗ ಮೆದುಳಿನಲ್ಲಿ ಊತ ಕಡಿಮೆಯಾಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಮೆದುಳಿನಂತೆ ಸ್ಕ್ಯಾನ್ ಪೂರ್ವ ಗಾಯಾಳುಗಳು ಸ್ವಲ್ಪ ಇವತ್ತು ಕಂಡುಬರುತ್ತದೆ. ಚಿಕಿತ್ಸೆಗೆ ಜನರಲ್ ಆಸ್ಪತ್ರೆಗೆ ಬಿಡುಗಡೆ ಮಾಡಿದ್ದು ಗಾಯಾಳು ದಿನಾಂಕ 21 ನಮ್ಮ ಪುಸ್ತಕದಿಂದ ಅತ್ಯಂತ ಪರೀಕ್ಷಿಸಿದಾಗ ಸಹಜ ವರ್ತನೆ ಇದೆ. ಕೊಡಲಾಯಿತು. ಗಾಯಾಳುವನ್ನು ಪರೀಕ್ಷಿಸಿ No, that neuropsychological assessment ಕಳಿಸಿದ್ರಾ? ಏನ್ ಹೇಳ್ತಾರ ಅವರು? Neuropsychological assessment reveals that she has full scale of IQ, falls under the category of dull normal level of intellectual ability. It falls under the category of dull normal level. ಎಲ್ಲಿದೆ? ಚಾಲನಾ ರಸ್ತೆ ಶುಕ್ರವಾರ ರಸ್ತೆ ಅಪಘಾತ ಒಳಗಾಗಿದ್ದು ಅವರು ನಮ್ಮ ಶಾಲೆಯಲ್ಲಿ ಬಿದ್ದು ಚಿಕಿತ್ಸೆಗಾಗಿ ತರಗತಿ ಬಹಿರಾಗಿದ್ದರಿಂದ ಸಾಲಿನಲ್ಲಿ ಮತ್ತೆ 19ನೇ ತರಗತಿ ವ್ಯಾಸಂಗ ಮಾಡುತ್ತಿರುತ್ತೆ ಎಂದು 1 ವರ್ಷ ಓದಿಲ್ಲ. It fall under that category of dull normal level of intellectual ability. Where is that evidence of the PW1? Will secure the records. Because she has lost 1 year. Yes, office is directed to secure original records from the tribunal. Yes.
Witness coming for appellant.
Yes. IA 2 of 2022 for dispensation of certified copies. Claim filing. Yes. On what ground you have challenged, Mr. Liability. Yes. 2 of 2022 for the reason stated in the accompanying affidavit. Production of certified copies of the judgment is dispensed. IA 2 of 2022 is allowed. Heard issue notice. Stay of judgment and award dated so and so. Subject to deposit entire compensation amount with interest before the tribunal within 4 weeks. High Court. No, since there is a delay, entire compensation amount before this High Court with interest. If delay is not there, then only 50%. Yes, in all cases. Before High Court. Yes. Second matter is also same. 34, yes, same.
Janardhan Reddy.
Yes, Janar. Huh? Yes, notice. Stay subject to deposit entire compensation amount with interest before the tribunal. Before the High Court within 4 weeks. 36 also same. View of that, production of certified copies of the judgment is dispensed.
Matter, serial number 37, M. Arun Punappa for appellant, T.S. Venkat Raju, S. Nirmala.
Punappa. Yes, where is Arun Punappa? What is this, Mr. Yes.
I'm the owner of the vehicle. In that context, award was not granted to me. However, 2 lakh, after that, comprehensive insurance policy, 2 lakh compensation was granted to me. That has been challenged before the court.
No, challenged by insurance company. Where is Arun Punappa? Pass over. Yes. Nagesh, none appear. Release this matter of 2 weeks.
For apparent, B. Pradeep. Number 39.
Shidhar. Office is directed to delete the name of D. Pradeep for R2. Yes.
Serial number 40, SN Keshava Prashant for apparent, KT Gurudeva Prasad.
Yes, Keshav Prashant. Keshav Prashant.
Serial number 40.
Yes, next week.
Serial number 41, Sarita Kulkarni for apparent.
My lord,
Mangalaya.
case of injury, my lord.
Ready, Mr. Mole?
Case of injury, my lord.
Yes.
My lord, the tribunal has awarded 3,50,550, my lord. The
Yes.
applicant, my lord, was an agriculturist and earning 20,000, my lord, claims to be 56 years at the time of accident, my lord.
Yes.
My lord, injury sustained, my lord, is sustained commuted displaced fracture of both bone.
Yes.
D 1/4 leg, my lord. Doctor has assessed the disability at 72%, my lord. Your
Yes.
lordships may kindly take paragraph 16 and 17, my lord. Paragraphs
Yes.
in page 12 of the judgment, my lord.
Yes.
Issue number 3, my lord.
Yes.
Lordships may kindly permit me to read para 16 and 17, my lord. The injuries, nature of injuries sustained, records are also been secured, my lord. 72% ಗೆ ಬರೀ 10% ತಗೊಂಡಿದ್ದಾರೆ. There is an ankle, doctor has opined clearly that the ankle replacement joint is required, my lord. Lordships may kindly find issue number 3 ಅಲ್ಲಿ last 4 lines. At the same time, the feedback of the treatment certificate discloses petitioner sustained comminuted displaced fracture of both bone D 1/4 left leg. Lordships have got. May I read? Lordships. OR plus IF with plates and screws. It is supported by the remaining document marked at Exhibit P9 and 10. Both discharge summary discloses petitioner has taken treatment as inpatient from 2011-17 to 27-11-17. Again, she was admitted on 2/8/18 and discharged on 10/8/18. And again 15 days.
Yes, we'll see that doctor evidence.
Please, my lord. Your lordships may kindly peruse doctor evidence. That is PW2, my lord. One Dr. Binny Kumar Singh, my lord. First page, my lord, it is stated that removal of implant from left tibia plus osteosynthesis of fibula with plate screws. Patient has subsequently come with regular follow-up. Clinical radiological examination, my lord, it is stated as malunited fracture of tibia lower 1/4, united fracture fibula with plate screw in situ, decreased ankle joints place. Your lordships have got it. On radiological examination may kindly be perused. Second page.
Where he said that
ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ arthritic changes in ankle and subtalar joint, periarticular porosis. As patient is developing arthritic changes in ankle and subtalar joint, she may require ankle joint replacement in future. And
he has not given each component's disability. He has said that disability is required 72%.
Please, my lord. And your lordships may kindly peruse even the photographs now noted. The nature of injuries may kindly be perused, my lord. Entire, she is unable to walk even today, my lord. Her ankle joint is Exhibit P14 may kindly be perused, my lord.
Now that you will see that cross-examination.
Please, my lord. Cross-examination, nothing is disputed, my lord. Nothing he. ಪಾಟೆ ಸವಾಲು ಎಲ್ಲೂ ಹೇಳಲ್ಲ ಅವರು ಇನ್ನು ಇಂಜುರೀಸ್ ಬಗ್ಗೆ ಏನು ಅವ್ರು ಕೇಳು ಇಲ್ಲ, ಇವ್ರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿಲ್ಲ.
ಆಯ್ವಾದಾಗ ಅಸಾಮರ್ಥ್ಯತೆ 6% 7 ಆಗಬಹುದೆಂದು ಸಾಕ್ಷಿದಾರರ ವಿಚಾರ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾರೆ.
ಅರ್ಜಿದಾರಿಗೆ ಆ ದಿನ ಎಡಗಾಲಿಗೆ ಹಿಮ್ಮಡಿ ಗಾಯ ಆಗಿರುತ್ತದೆ ಅಂದ್ರೆ ಸರಿ. ಅರ್ಜಿದಾರಿಗೆ ಹಾಕಿದ್ದ ಪ್ಲೇಟ್ ಮತ್ತು ಸ್ಕ್ರೂ ಒಂದಕ್ಕೆ ತೆಗೆದಿರುತ್ತಾರೆ. ಸಾಕ್ಷಿ ಒಂದು ಪ್ಲೇಟ್ ತೆಗೆಯುತ್ತೆ, ಮತ್ತೊಂದು ಪ್ಲೇಟ್ ಹಾಕಿದೆ ಎಂದು ಹೇಳ್ತಾರೆ. ಬಾರಿ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡುತ್ತಾರೆ. ಎಷ್ಟು ನರ್ಸಿಂಗ್ ಚಾರ್ಜ್ ಆದರೆ ಚಾರ್ಜ್ ಮಾಡುತ್ತದೆ ಅಂದ್ರೆ
Only the nursing charges, doctor says it depends on the nature, type of room they obtain. The expenses will be based on the.
ಯಾವುದೇ ಅಂಗನಂಟು ಇಲ್ಲದಿದ್ದರೂ ಸಹಿತ ಸಹಾಯ ಮಾಡುತ್ತಾರೆ. ಸರಿಯಲ್ಲ.
Exhibit P14 may kindly be perused, my lord. P14 discloses the nature of injury she sustained, my lord.
Yes.
Kindly, it may be kindly perused, my lord. For having sustained 72% disability, my lord, tribunal has taken 10% disability, my lord.
Yes, we'll consider.
Please, my lord. And in so far as the income is concerned, my lord, 9,000. Date of accident is 2011-2017, my lord.
17 or 19?
ಇಲ್ಲ 17 ಅದು ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ತಪ್ಪಾಗಿದೆ.
Yes.
17, my lord. 9,000 income has been taken, my lord.
Yes.
10% disability in page 15 ಅಲ್ಲಿ it is forthcoming, my lord.
Yes, yes, sir.
Please, my lord.
Yes. That's all.
15 days, my lord, she was inpatient.
Yes.
My lord, the future medical expenses also we are claiming, my lord, because there are implants which are there.
Oh,
ಆಮೇಲೆ
what is
joint
that?
ankle joint replacement ಅಂದ್ರೆ it is it's a major
Have the-
surgery, my lord.
Have the doctor said what is that future medical expenses you require?
Expenses ಅವ್ರು ಹೇಳಲ್ಲ, only the it is
But there is no estimation. There is
estimation
no
ಅವ್ರು ಮಾಡಿಲ್ಲ. Maybe, my lord, it is not
reports ಅಂತ ಹೇಳ್ತಾರೆ.
implants. The one implant is taken out and the other implant is there, my lord. And in
Yes.
so far as ankle joint replacement, it is forthcoming in the doctor evidence, my lord. ಹೇಳ್ತಾರೆ severe pain around left ankle foot, difficulty in walking,
Yes,
difficulty in
Not all injuries is united. One fracture is united. Other is malunited. It is
tibia
an
lower
ankle
back bone
injury.
is malunited.
It is an ankle fracture. It is a weight bearing bone. It is ankle. It is very important. Yes.
Moreover, she is a lady.
Yes. That's all. Srimati Sarita Kulkarni, Senate Council appearing for climate has contended that to that extent the climate has suffered grievous injury. She has examined Dr. S. PW2. In his evidence, he has deposed that the climate has suffered 72% disability towards left ankle, left lower limb. The ankle was fractured. The fracture was malunited. She was unable to do her day-to-day work. The tribunal has assessed the whole body disability is 10% is on lower side. She further contended that due to that extent, the claimant has suffered grievous injury. She was inpatient for a period of 5 days. She has suffered
15.
lot of pain. 15 days.
15 days, I believe.
She has suffered lot of pain during the treatment. She has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. She further contended that due to that extent, the claimant has undergone surgery. Doctor has deposed that she has to undergo one more surgery for removal of the implant. They require for ankle replacement. The tribunal has not granted any compensation for future medical expenses. Hence, he sought for enhancement of compensation. For contra, so and so learned counsel appearing for the insurance company has income contended that even though doctor has deposed that the claimant has suffered 72% disability to particular limbs, he has not assessed the whole body disabilities. In cross-examination, he has denied the suggestion that disability suffered by the claimant is 6 to 7%. He further contended that yes, he was unable to the suggestion. He has answered that what he said. He has deposed that he is not aware of that.
ನ್ಯಾಯವಾದದ ಅಸಾಮರ್ಥ್ಯತೆ ಶೇಕಡ 6ರಿಂದ 7 ಆಗಬಹುದು ಅಂದರೆ ಸಾಕ್ಷಿದಾರರು ಆ ವಿಚಾರ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದು ಹೇಳ್ತಾರೆ.
ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳುತ್ತಾರೆ.
ಡಾಕ್ಟರ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಇಂಥಾರು ಹೇಳ್ಬೇಕು.
Maybe my lord, the type nature of question put on him, maybe he's stated like that.
Yes. He further contended that considering that evidence of doctor and injury suffered by the claimant, the tribunal has rightly assessed the whole body disabilities 10%. He further contended that even though the claimant has claimed that she was earning 20,000 per month, she has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 9,000 per month. She further contended that considering that evidence of doctor injury suffered by the claimant, the compensation awarded to the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, he has contended that even though doctor has deposed that the claimant is required to undergo one more surgery, he has not given any estimation of further surgery. Therefore, the tribunal rightly has not granted any compensation for future medical expenses. And he further contended that the interest awarded by the tribunal 8% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 20th/11/2017 due to rash and negligent driving of rider of motorcycle bearing registration number KA 17 EF 2225. Due to that extent, the claimant has suffered the following injury: She has examined. Dr. Dinya Kumar Singh as PW2. In his evidence, he has deposed that the claimant has suffered displaced fracture of both bone, distal, one of left leg, one-fourth left leg,
Left leg.
and he deposed that all united fracture tibia lower 1/4, united fracture fibula with plate screw in suit, decreased the ankle joint space, and
Disability period they had given very clearly.
what is that?
Exhibit P8. Only one injury, that is communicated displacement fracture of both and one-fourth left leg. He was treated with
As per the exhibit P8, the claimant has suffered ankle fracture, and he has deposed that the claimant has suffered 72% disability to left ankle. Considering that evidence of doctor injury suffered by the claimant, I am of opinion that the whole body disabilities can be assessed 20%.
Lord, even 1/3 ತಗೊಂಡ್ರು 24% ಆಗತ್ತೆ. ಎಲ್ಲ ಎಕ್ಸಿಬಿಟ್ P8 ಅಲ್ಲಿ ಬಂದಿದೆ malunited fracture left tibia lower 1/4 ಅಂತ. Exhibit
Yes, I
P8
heard. Yes, I heard both of you, and I deciding my yes.
Yes.
Yes. 20%. Even though the claimant has claimed that she was earning 20,000 per month, she has not produced any document to establish the same. Under those circumstances, the notional income must be considered as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, the notional income must be considered as 11,000. At the time of the accident, she was aged about
46 months.
46 years. The multiplier applicable to that age group is 14. Accordingly, 14 ಹಾಕಿದಾರಲ್ಲ ವೈ
5 years of
45 gestures. Yes, 45 years. The multiplier applicable to that age group is 14. Accordingly, loss of future earning has been reassessed as well. Yes. Due to that extent, the claimant has suffered the above said injury. He was inpatient for a period of 15 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering 30,000 to 40,000. Loss of immunities from 10,000 to 30,000. Loss of income during the later period for 3 months. In respect of future medical expenses, due to that extent, the claimant has suffered the above said injury. She has undergone surgery. Doctor has deposed that the claimant required to undergo one more surgery for removal of the implant. Considering that evidence of doctor injury suffered by the claimant, I am of the opinion that the future medical expenses can be awarded 20,000 rupees.
Ankle replacement.
ಏನು ಹೇಳಿಲ್ಲ ನಿಮ್ ಡಾಕ್ಟರ್ ಸುಮ್ಮನೆ 75%. You see the disability certificate, nothing is there in the disability certificate, but they have not initiated anything from the cross examination by the doctor. Yes, enhanced compensation amount There is 6% interest. Yes.
Obliged, madam. Amenities only 10,000 was given.
No, I have enhanced. You just see that order. Yes.
Please, madam, obliged.
Yes, wait for your turn, Mr. Pasto. Yes.
Number 42 adjourned, serial number 43, Manjunath N.D. for appellant, Janardhan Reddy.
Yes. Ready? Ready? Yes. 19/7? Yes. 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 Hmm. Hmm. Where is the discussion of the tribunal regarding the disability? That ignorance about what kind of treatment the petitioner has given other hospital in examination of the petitioner surgeon or urologist who examined the petitioner, he stated that others was jointly performed the two surgery for the so. ಎಲ್ಲಿದೆ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ? ಏನು what are the injuries, Mr. ಏನು injuries to that urinary bladder? ಎಲ್ಲಿದೆ injury?
Page number 14. There are 24 discussion. Series discussion. 123.
Large laceration with hematoma and acute bleeding in the region of cranium, bleeding from the tip of the urethra, peripheral tenderness, swelling due to the bone fracture, 3 mild swelling septum. Respiratory rate of 24, oxygen situation 98% after discharge. He was treated antibiotic leave after 7 days looking. He reviewed with me and sent to complain the payment of peripheral wound. He was review shows that peripheral wound has healed 90% except for the small cranial wound has healed 90% except for small. Honest is personal excellency was sent to our after considering the further questioning to review with the doctor, we are advising to review that. Because the people who are There is a serious injuries in that. No, that will secure that original records. Serious injuries are there. Office is directed to secure original records from the tribunal.
Number 44, put the agreement for appellate.
Yes.
Appear for the respondents case.
Ready.
TCR ಬೇಕಾದ್ರೆ ಅನ್ಸುತ್ತೆ ಸುಮ್ಮನೆ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇಶ್ಯೂ ಇದೆ 40% negligence is against the motorcycle. 60% against me.
Office is directed to secure original records from the tribunal.
Number 45 version, number 46, Sri Vidya DK for appellant,
I prefer second respondent.
Yes, madam, ready. Dismissed. Yes, heard. Admit, yes.
Number 47. For appellant, New Yerala E, Kantarajappa.
Yes. One up. You are appearing for whom? R1 is that owner, employer. No, that are you disputing that or happy that somebody has been given a responsibility? Why? No, but he has given a contract to somebody, then he is not responsible. Number two, how can Mestri is responsible? If he is an employee of that Mestri is no that. Yes, we'll see. Yes, we'll secure the records. Each had to be called. Office is directed to secure original records from the tribunal.
48, AM Venkatesh for appellant.
I am appearing for the appellant, my lord.
Yes, Mr.
So my insurance company appeal on liability issue, my lord.
What are that substantial question of law, Mr.
My lord, there is no employee-employer relation between the deceased and the insured. And there is no DL at all for the deceased, who was also charge sheeted by the police, my lord. My lord, kindly come to para 3 of the learned MACT.
Yes, heard. Admit.
Please, my lord.
Substantial question of law arises for consideration whether the tribunal is justified. Tell that the claimant has proved the employers and employees relationship between the deceased and who is that owner?
My lord, actually owner is Muniamma, sir. On the date of accident, Muniamma is the insured, but Sanadevamma was also included as previous owner, my lord.
Now, what is that finding of the tribunal, Mr.?
My
Who
lord,
is that one? No, Mr. I am framing the substantial question of law. You say who is that owner which is held by the tribunal?
Muniamma, my lord.
That's justified. The proved that the claimant deceased was working under second respondent Muniamma. Substantial question of law. What is that? Whether the tribunal has justified fastening the liability on insurance company when that insured has violated the policy condition. Yes.
Please, man.
Number 49, adjourn. Serial number 50. Venkatesh Gowda case for appellant. Sumana Baliga AM Krishna Swamy.
50. Yes. Yes, their income.
Only is admitted in the evidence in the objection statement.
Hmm.
They are paying 195 fees, 195, 82 paisa per month. 8,824 per month.
Hmm. Criminal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ 3000 ತಗೊಂಡಿದ್ದಾರೆ 5000 per day ನಾ per month
195 fees, 82 paisa per month.
per day ಎಷ್ಟಾಯ್ತು monthly what is the date of the accident 2013 maximum is 4000 or 8000 yes. Maximum is 8000 but according to you it is 5000 874 that is the only dispute all other aspects that is 12% is it settled
95.82 calculated for 26 days under easy act 30 days in
ಬರಲ್ವಾ ಎಷ್ಟು ಬರುತ್ತೆ 26
4 days
will tell you
195.8 to 26 months.
ಎಷ್ಟಾಯ್ತು 98
26.
5091.32.
yes
Therefore, that they will be given 830.
ಅದು ಒಂದೇ ಅಂದ್ರೆ you are liable for only that remaining owner has to pay yes interest 12% it is settled ಅದು owner now who is appearing for the owner then Suman Balika when do you want next week yes next week that is the only issue we will interest it is a statutory but ಕೊಟ್ಟಿಲ್ಲ ಅದರಲ್ಲಿ that will clarify only the thing is that owner has to pay and that balance salary has to pay by the remaining period you are yes yes next week madam no that only thing is that enhanced salary ಅಲ್ಲ declared ಎಷ್ಟಿದೆ 3000 that balance has to be ಅಲ್ಲ tribunal has cost and liability on you only in respect of 3000 830 we have to 830 ಗೆ ಮಾಡಿದಾರ ಮತ್ತೆ only now that you and between that owner yes tomorrow next week yes
connected matter P. Nataraju.
on what ground they have challenged this and then that will not come
My lord, serial number 45. Serial number 45, I am appearing for respondent number 1.
Sir, 51 ನಡೀತಾ ಇದೆ sir, 51.
Sorry, my lord, sorry, my lord.
or you are appearing for the owner yes You take notice in that cross objection. Now, what is that this thing? There is no this thing, reduction from the salary. Then that ಎಷ್ಟು ದಿನ ನೀವು ರಜಾ ಇದ್ದೀರಿ? Pain and suffering go. I thought that 2,35,346 will go. ಹೋದ್ರೆ ರಿಮೈನಿಂಗ್ ಎಷ್ಟು ಉಳಿತು ನೋಡಿ. ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ 40,000, 20,000, 15,000, 37,131.
1,12,131.
1,12,000 ಆಯ್ತು. ಆಯ್ತು, ಎಲ್ಲ ಮಾಡಿ ರೌಂಡ್ ಫಿಗರ್ 2 lakhs ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. ಏನಿಲ್ಲ ಅಲ್ರಿ, ಜಸ್ಟ್ ಸಿ ಅವರು ಎಂಪ್ಲಾಯಿ ಅಲ್ದಿದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಪೇ. ಇಸ್ ಇಟ್ ನಾಟ್? That you are disputing, we will verify. If you are not disputing only quantum, I said. If you are disputing that, we will see that original records, whether finding of the tribunal is right or wrong. 1,12,000 ಕೊಟ್ಟಿದ್ದಾರೆ. What is the date of the extent? 2018. 2018 ಅಂತಂದ್ರೆ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 75,000 ಅಲ್ಲೇ ಆಯ್ತಲ್ರಿ. 40 ಕೊಟ್ಟಿದ್ದಾರೆ, 50, 25, 35. ಅಮ್ಯುನಿಟೀಸ್ ಯು ಹ್ಯಾವ್ ಟು ಗಿವ್ 20,000 ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಲ್ಲಿ 30, 35, 65. ಕರೆಕ್ಟ್ 2 lakhs. ವಾಟ್ ಐ ಸೆಡ್ ಇಸ್ ಕರೆಕ್ಟ್. ಇಫ್ ಐ ಆಯ್ತ್ರಿ, ಇನ್ಸೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಇಲ್ದಾನೆ ಹೌ ಕ್ಯಾನ್ ಯು ರೈಡ್ ಏನೋ ಯೂಸ್ ದಟ್ ವೆಹಿಕಲ್? 160 ಅಲ್ಲ. If you see pain and suffering and amenities, they have given only 20,000. No, 40,000. 2018 we are granting 60 to 70,000 depending upon the injury. 70, 1 lakh. ಟ್ರೀಟ್ಮೆಂಟ್ ನಿಮಗೇನು ಸ್ಯಾಲ್ರಿ ಕೊಟ್ಟಿಲ್ವಾ? ಎಷ್ಟು ದಿನ ಲೀವ್ ತಗೊಂಡಿದ್ರಿ? ಆಯ್ತಾ? ಓಕೆ. Then we'll secure that records. Yes. What is that discussion regarding the tribunal regarding loss of income during the laid-up period? ಅಲ್ಲ ಆಯ್ತು, ಇನ್ಕಮ್ 27,000 ತಗೊಂಡಿದ್ದಾರೆ. Why tribunal has not granted any loss of income during the later period? Yes. 4 days, 5 days. He was hospitalized about 5 days. ಆಯ್ತು, ಡಿವೈಡೆಡ್ ಬೈ ಸ್ಯಾಲ್ರಿ ಎಷ್ಟು ಇದೆ? ಡಿವೈಡೆಡ್ ಬೈ 5 ಅಂದ್ರೆ ಎಷ್ಟಾಯ್ತು?
Divided by 5. 5,400.
5,400. ಅದು ಎಲ್ಲಿ ನಿಮ್ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲಿದೆ? ನಾನು ಓದಿ ಅಲ್ಲ, ನಿಮ್ ಎವಿಡೆನ್ಸ್ ಕೊಡಿ. ವೆದರ್ ಯು ಆರ್ ನಾಟ್ ಅಟೆಂಡೆಡ್ ದಟ್ ಆಫೀಸ್, ಸ್ಯಾಲ್ರಿ ಹ್ಯಾಸ್ ನಾಟ್ ಬಿನ್ ಪೇಡ್, ಆಲ್ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು. ಆಯ್ತು, 2 lakhs. He said yes. ಆಯ್ತು, 1,80,000. ಆಯ್ತು ಬಿಡಿ. Naturally, if case is yes sir, undertake to appear for respondent number. ಒಬ್ರೇನಾ? All respondent will appear. Take appear for respondent. Office is directed to show his name. Shri Pradeep KC, Karnataka counsel appearing for the owner of the offending vehicle has contended that it is not in dispute. The claimant was working as a conductor in KSRTC, a driver in KSRTC. Even after recovering from the injury, he has continued in his service. There is no loss of income due to that disability or accidental injury. The tribunal has error in granting loss of future income due to the disability. He further contended that the injuries suffered by the claimants are minor in nature. He was inpatient for a period of 5 days. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on higher side. Hence, he sought for reduction of compensation. For contra, the Nataraj learned counsel appearing for the claimant has contended that due to that extent, the claimant has suffered you will do one thing, because you have to reduce that interest because your appeal is there. Now it is from 9% to it has to be reduced to 6%. Make it as in a 2 lakhs. Reduce that interest to 6%. It will save because your appeal is there. In all cases, I have held that 6%. I can't, even though you are not argued, but I have seen that. I can't continue that interest 9%. Yes. Contended that the injuries suffered by the claimants are previous in nature. He was inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Our contention interest on that. Apply. Heard the learned counsel for the parties arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 23/11/2017 due to rash and negligent driving of rider of motorcycle bearing registration number KA13X8290. Due to that accident, the claimant has suffered the aforesaid injury. At the time of the accident, he was working as a driver in KSRTC. Even after recovering from that injury, he has continued in his service. There is no loss of income due to the you can loss of income due to the disability. Therefore, the tribunal is not justified in granting the compensation for loss of future income. The claimant is not entitled for loss of future income. In respect of compensation awarded by the tribunal, in respect of other head, the compensation awarded by the tribunal is 1 lakh 40,000, 20,000, 60 plus 15, 37,130.
1,12,131.
In the other hand, the overall compensation awarded by the tribunal is 1,12,131. The same has been enhanced to 2 lakhs with 6% interest. The interest awarded by the tribunal, 9% has to be reduced to 6%. Accordingly, the appeals are disposed of. Judgment and award passed by the tribunal is modified as follows. The owner of the offending vehicle is directed to deposit 2 lakhs rupees with 6% interest within 6 weeks from date of registered copy of the service. Amount in deposit is transferred to the tribunal. In view of disposal of the appeal,
Interest to the date of it.
ಅದಿದೆ ಅದು ಮಾಮೂಲಿ. Has to pay the interest from the date of petition till payment 6%. IA will not arise this for consideration.
Girimalaya for appellant, Ravi H. Samprati.
Yes, ready. Case of death. What is the age of the deceased? Hmm. 9,000. Two 2017 ಅಂತ ಅಂದ್ರೆ ನೀವ್ ಎಷ್ಟು ಕೇಳಿದ್ರಿ? 15,000. ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಟ್ಟಿದಾರಾ? ಯಾರ್ಯಾರು? Who are that? Which is that MEC? 2494. Who is that first claimant? Is that father? Second is the mother. Who are that others? They are not entitled. Yes, Kavali. Sri Girimalaya, learned counsel appearing for. The claimant has contended that at the time of the accident, deceased was earning 15,000 per month. The tribunal has granted, consider that notional income of the deceased as 9,000 per month is on lawyer side. He further contended that in view of judgment of apex court in case of Magma, the claimants are entitled 44,000 each. Hence he sought for enhancement of compensation. For contra, the Ravi learned counsel appearing for the insurance company has contended that even though the claimant has claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. The circumstances, the tribunal has rightly assessed that the notional income of the claimant as 9,000 per month. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal 9% is on their side. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. Imran Khan died in road traffic accident occurred on 31/12/2017 due to rash and negligent driving of driver of car bearing registration number KA41 C0429. Even though the claimants are claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. Under that circumstances, the notional income has to be considered as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2017, the notional income has to be considered as 11,000. The tribunal has rightly added 40% of the income of the deceased for future prospects. Deceased was a based bachelor. 50% of the income of the deceased has to be deducted for personal expenses. The multiplier, he was aged about 22 years. The multiplier applicable to that age group is 18. Accordingly, loss of dependency has been reassessed. 11,000.
50%, 7,700. 7,700 into 12 into 18, 16,63,200.
In addition, 16,500 for loss of estate, 16,500 for funeral expenses. In view of judgment of apex court in case of Magma, the first claimant is entitled 44,000 for loss of first claimant number 1 and 2 are entitled 44,000 each or Phenol Consortium. The enhanced compensation amount carries 6% interest.
Party for appellant, Gopal Krishna N.
Yes. Achok, ready? Quantum. Yes. Hmm. What are the injury? Hmm. Hmm. 1/3 right tibia, anterior fibula, so right fracture, medulla, so Osmot Hospital. After BS, great difficulties in pointing and sustained you are so. It was across into the whole body 22, 40% towards the need of special shock. Skin application in skin grafting. Yeah.
I'm not on that.
Hmm.
50%.
Hmm.
6,000.
Hmm. Hmm.
I'm only not that yes, if it not 1,50,000.
Date of accident yavaga?
They are not in appeal.
Even then. Two lakh.
2,75,400.
Hmm.
91,800.
91,800. 1 lakh. Allige pain and suffering go, it's maybe. Agni, you have not challenged that topic. See, these are all settled principle. Even then, I can take that as in a 9%. 9,000. Yes, I will consider. Whatever. What? Yes. Yes.
Consider the overall 15%.
Hmm.
Not the maximum, the tribal could have awarded him not 70,000.
Yes.
Awarded not way ahead of its not.
Yes. What about that future medical expense? ಎಷ್ಟು ತಗೊಂಡು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
Annually, there is a chance of deformity. Operation, right? Which may require correction in future.
Yes.
In the event only, there is no confirmation at the time when he not before. He says they require in future in the event of that.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು?
1 lakh is awarded.
1 lakh.
Therefore, according to the doctor, the removal of implant is 40,000 and but all this occurs only 1 lakh. Taking into consideration what will not happen because they are talking
Now we will do one thing, we will reduce 50,000 plus 6% interest. We'll close it. Yes, Mr. That's all. Even I calculate also, it will come to that. See, pain and suffering and income, even though 75,000 more, but if you take in that income, it will compensate. In only another ground for you is that future medical expenses. At least another 50,000 can be reduced. Interest. Then 6% interest. All your purpose is that. 3. Party learned counsel appearing for. The claimant has, insurance company has contended that. Criminal interest ಕೊಟ್ಟಿಲ್ಲ. ಹೌದಾ? That is not entitled. That will clarify. Has contended that the injuries suffered by the claimants are minor in nature. He was inpatient. Yes, Dina. Was inpatient for a period of 12 days. The compensation, 12 days. The compensation awarded by the tribunal for pain and suffering is on a higher side. He further contended that even though doctor has deposed that the claimant is required only 40,000 for removal of the implant, he has not. What is that another ground he has said? Shocking, sir. Huh? 7,000 to 8,000 he required for shockings and Vaseline applications, but he has not produced any estimation for that, and the claimant has not produced any document even before this court that he has spent any money for future medical expenses. Lastly, he has contended that in view of judgment of this court, the interest awarded by the tribunal 8% is on higher side, and the tribunal has error in awarding interest for future medical expenses. Hence, he sought for allowing that appeal. Per contra, Sri Gopal Krishna N, learned counsel appearing for the claimant has contended that at the time of the accident, he was earning 15,000 per month. The tribunal has assessed the notional income of the claimant as 6,000 is on lower side. He further contended that due to that extent, the claimant has suffered previous injury. He was inpatient for a period of 12 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering and other head are just and reasonable. Lastly, he has contended that due to that accident, he has undergone surgery. He required to undergo one more surgery for removal of the implant, and he requires 7,000 to 8,000 annually for shocking and other medical expenses. Considering the same, the tribunal has rightly awarded future medical expenses of rupees 1 lakh. Therefore, he contended that, therefore, he sought for dismissal of the appeal. Heard the learned counsel for the parties, arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 19/5/2015 due to rash and negligent driving of driver of car bearing registration number K7M226. Due to that accident, the claimant has suffered the following injury: He was inpatient for a period of 12 days. He has suffered a lot of pain during the treatment. Even though the tribunal has the compensation awarded by the tribunal for pain and suffering is on higher side, but the compensation awarded by the tribunal for loss of income during the later period is on lower side. Considering the same, I am of the opinion that the overall compensation awarded by the tribunal in both the head are just and reasonable. In respect of future medical expenses is concerned, the claimant has suffered the above said injury. He has examined the doctor. Doctor has deposed that the claimant required 40,000 for future medical expenses for removal of the implant and 7 to 8,000 for annually for shockings and application of Vaseline. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that the compensation awarded by the tribunal for pain and suffering has to be reduced to 50,000 from 1 lakh. In view of judgment of the apex court, in view of the judgment of this court, the interest awarded by the tribunal has to be reduced to 6%. The future medical expenses will not carry any interest. Accordingly, the appeals are allowed in parts. Judgment and award passed to the tribunal as modified as well. 50,000. Yes, that's all. Amount in deposit is transferred to the tribunal. No, it requires. But if you're comparing to that, that's what I said. Definitely it is higher side. But see that income it is assessed. Disability, you are happy. You are not challenged. Yes.
55, Mandula and Tejasvi for appellant, connected matters, Purti Egdayan, Shivakumar.
Yes. Gather. How about that? You just yes, fifth, fourth.
Number 56, Palakaya for appellant, connected matter, Kumake.
Yes. Suma. Who is it? Sumake Palakshaya 50%. Paso.
Ravishankar for appellant, connected matter, Mantaraj K.
Yes, where is that Ravishankar? What is this, Mr. Next week. Yes, none appear for respondent. Release this matter up to 2 weeks. Yes. Why is that on? Yes.
He made around 70 years.
Yes, heard. Admit. Allah heard. Issue notice. There. Judgment and award dated. June 2022 passed by MACT Chikanaikanahalli in MAC 354 of 2020, subject to deposit of 16,45,900 before the tribunal, with interest before the tribunal within 4 weeks. Yes. Alla alli tribunal alli ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಡಿಪಾಸಿಟ್ ಅಲ್ಲ ಡಿಪಾಸಿಟ್ ಏನಾರ ಮಾಡಿದ್ರೆ if I permit 50% can be permitted out of the total. Yes, out of the total compensation directed to deposit within 4 weeks. The claimant is permitted to withdraw 50% of the amount which is deposited before the tribunal after due verification.
Number 59, Nagaraj K for appellant.
Yes, Mr. Nagraj. Unmute ಮಾಡಿ.
Sir, mic mute ಆಗಿದೆ. And this appeal is filed by the owner of the bus challenging the judgment and award on the ground that as per police records, he was traveling, the passenger was traveling with inside the bus. As per the hospital records, he was traveling on the top of the bus. The tribunal accepted the version of the hospital authorities and awarded compensation irrespective of.
No, hospital document says.
Yes. But hospital ನಲ್ಲಿ ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ಯಾರು ಇದನ್ನ ಇನ್ಫಾರ್ಮೇಶನ್ ಮಾಡಿದ್ರು ಏನು ಎತ್ತ ಅಂತ ಇಲ್ಲ ಅಲ್ಲಿ. ಆಮೇಲೆ ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. They have not sent the report to the police. They says that they have sent the report to the police, hospital authorities. There is nothing on record. I have examined the doctor who has treated me, but Malas who has at the time of admission, somebody was there. Malas, he says that Malas, the victim was traveling on the top of the bus.
You are the owner of the bus, you are liable. You
Yes.
have allowed to,
Malas,
it is not any insurance company to say that, yes.
Yes, but there is no evidence to show that he was traveling inside the bus or on the top of the bus. Though sufficient evidence is there, Malan, the eyewitnesses are there, Malan, none of them has been examined.
No, that there is no dispute regarding that accident, involvement of your vehicle.
Involvement of the vehicle is not, Malan, that itself is a dispute, Malan.
You deposit 50%.
That's ಸ್ವಲ್ಪ ಜಾಸ್ತಿ time ಕೊಡಿಸು.
Yes, issue notice, hard issue notice. Stay of judgment and award dated 12th August 2022 passed by MESCT Chitradurga in MEC 474 of 2019, subject to deposit 50% of the award amount with interest before the tribunal within 8 weeks.
Please, ma'am.
8 weeks from today.
Number 60, this is Sitaram Rao for appellant.
Yes, Sitaram Rao. Yes. Liability or challenging? Why? Yes, issue notice, hard issue notice, stay up. Which is that MESC? 6503 of 2010, subject to deposit of 50% of the award amount with interest before the tribunal. 50% you have already deposited. How much? That is, how much you have deposited? 25,000 different, Mr. Yes, 50% of that award amount with interest before the tribunal within 4 weeks.
Yes, Samprati.
Yes. In disability. Yes. Hard issue notice. Day of judgment and award dated 22nd July 2022 passed by MECT Bangalore in MEC 5134 of 2019, subject to deposit 50% of the award amount with interest before the tribunal within 4 weeks.
Serial number 62 appear for respondent number 1, my lord.
Yes, yes. Where is the
insurance company? Appellant
Ramamurthy. Who is Ramamurthy? None appear for that appellant as a last chance for release this matter.
2 weeks kodi. Last 3-4 sala bandidane. 2 weeks kodi.
Allah, I will dismiss it. Last time I have noted.
Ade sumar sala bandide agle illa.
Yes, yes. Release this matter at the request. When the matter is called on 18/10/2022, none appear for the appellant as a last chance. Matter was posted today. Even today, when the matter is called, none appear for the appellant. It appears that appellant is not interested in prosecuting the case. Hence, dismissed for default. 2011 matter.
Ade sumar sala bandide.
Yes.
Nityananda arrest for appellant connected. O Mahesh, Christopher Noel,
Chidanand arrest. Also, let us see.
number 64. A Venkatesh for appellant, H. Ramachandra, M. S. Narayan, D. M. Subramani, A. Vishwanath.
Yes.
I am appearing for the appellant, my lord. So my insurance company appeal. Appeal is not maintainable under 163A, my lord. They approved that he was drawing 10,000 rupees salary per month.
Yes, Mr.
Swami, insurance company appeal 163 is not maintained well, my lord. He was drawing a salary of rupees 10,000 rupees per month. They have restricted his income. My lords, come to para 12, page 14 of the learned MACT judgment, my lord. Though it was declared that his salary, he was drawing a salary of 10,000 rupees. They have restricted their income to the 3,300, my lord. So hence the appeal is to be allowed. A petition is not maintainable when they restrict the income of the deceased to 3,300 rupees, my lord, to just get a from the.
What is that law on that point? It can be. I think some judgments are there.
Yes, my lord. One of the judgments of this court, my lord. This is MFA 41474-708 of 2007 by Justice V. Jagannathan.
So what about the recent judgments? I think it can be restrict, Mr. It can be restrict.
Recent judgment of this court, my lord, MFA 5904. Supreme Court of full bench judgment, my lord, 2004 ACJ 934. Para 51.
Sir, citation repeat ಮಾಡಿ sir.
2004 ACJ 934. SC. And division bench judgment of this court in 2000 ILR 2007 Karnataka 28. Para 6, my lord. Para 6 and 15. Shall I read, my lord, para 6?
Wait, we'll get the judgment.
Sorry, sir.
Yes, read.
My lord. Para
Yes,
6,
Mr.
my lord. Para 6 of the division bench judgment, my lord.
Yes, Mr. Narayan, you are appearing for whom?
Respondent number 4, my lord.
The claimant.
KSRTC.
Who is appearing for the claimant?
Ramachandra.
Yes, we'll pass it over. We'll see afternoon. If he is not
Aitu,
coming,
my lord.
pass over.
Appellant, Sabur, government advocate.
Yes, Mr. Hegde, what is this? Who is contesting? State. Climate. You are appearing for a Land Army Corporation. He is appearing for respondent number 4, served unrepresented. What ground you are challenging, Mr. Or R1. Where is that manner of the accident? Wait, Mr. Raghu. 1 and 2 ge Prabhu for R1. Now the advocate.
ಅವ್ರು ಮುಂಚೆ ಫೈಲ್ ಮಾಡಿದ್ರು ಜೊತೆಗೆ ಜಾಯಿಂಟ್ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಬೋರ್ಡ್ ನೋಡ್ಬೇಕು
ಜಾಯಿಂಟ್ ವಕಾಲತ್
ಅಂದ್ರೆ ಇನ್ನೊಬ್ರು ವಕಾಲತ್
ಇವ್ರು ಯಾವಾಗ ಹಾಕಿದ್ರು?
ಹೇಳಿ ಸಾಬೂರು ಇನ್ ದ ಇಯರ್ 2013 ಸರ್ ಇವ್ರು ಇವಾಗ ಹೊಸದಾಗಿ ಮೇ 22
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿಲ್ಲ ಎನ್ಒಸಿ ಇಲ್ಲ
ಇಲ್ಲ ಸರ್ ಏನು ಮಾಡಿಲ್ಲ.
Some other counsel has filed an wakalat. Office has not shown his name.
ಪಾರ್ಟಿ ಹೆಸರು ಲಕ್ಷ್ಮಣ್.
No, nada. Yaar ಮಾಡಿರೋದು? V. Srinivas has filed wakalat for respondent number 1 and 2. Office is directed to show his name. Release this matter next week.
Then Krishna for appellant, Subhash Rajesh, Anita, Vishwanatha Pujari.
Yes, Mr. What ground you have challenge? Hmm. 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 No, no, it is not under that. But under CPC, he can file in a review. No, CPC is not applicable. Oh, sir, applicable, sir, only certain, yes.
Your person incest to police, see the vehicle that is involved. And where vehicle is happening. That is the wrong abuse.
No, because in so many cases, even insurance company is also filing in a review before the tribunal, saying that we have filed in a review. What is motor vehicle section? What is the section 151 Motor Vehicles Act? CPC can be made applicable. Fraud. No, applicability of the CPC in which is the provision under Motor Vehicles Act? Purpose of taking the evidence 169. Holding any current.
Chapter 26 of Code of Civil Procedure report.
Hmm.
Described and we have procedure holding 254. Testing of powers and state code to the tribunal 253 members.
Is that says what are the powers?
Not ready. If it plans to exercise or any of the powers vested in civil code
following from procedure is not made. Insofar as they may be applicable mainly section 30, 32, 34 is the reason why more than 6 months. 71 unit. C 76, 77, 84, 95, 142, 142, 144, 145, 147, 148, 151, 154, 158,
147 ಇಲ್ಲ.
14 procedure of holding in file. Is it to address the applicable.
As who is appearing for other side? Involvement of vehicle. What is that? When that accident has occurred? On 21/7/2020. Disposed of on that. Accident is occurred on. Then he has immediately admitted to hospital.
Yes, sir.
What is that medical record says?
Statistic needs number one time. Area 14L 6526. Yes, area 14
Is there any reason for that? I think he has not properly noticed that vehicle when he has met with an accident.
Well, read the evidence of petitioner.
Yes. Yes. Yes, sir. Yes. 1910.
Well, I am. Yeah.
Which is it? In his evidence. Yes. Where you are reading? Yes, yes, yes.
Complaint. Correct the video.
Yes. Yes.
ನಾನು ಏಕಡೆ ನಿವಾಸಿಯಾಗಿರುತ್ತೇನೆ ದಿನಾಂಕ 19/10/2019 ರಾತ್ರಿ 8:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಊಟ ಮಾಡಿ ಕುಳಿತು ಯಾರೋ ಗಾರೆ ಕೆಲಸ ಕುಡಿಸುತ್ತೇನೆ ಮುಖ್ಯರಹಳ್ಳಿ ಪಕ್ಕದಲ್ಲೇ ಬಿದ್ದು ಬೈಕ್ ಸವಾರ ಬೈಕ್ ಮುಂದೆ ನಿಲ್ಲಿಸಿದ್ದು ಬೈಕ್ ನಂಬರ್ ನೋಡಲಾಗಿ
Yes. KA14.
KA14 6526. ಈಗ 100 ಮುನಿಕುಮಾರ ಅಂತ ಬರ್ತಾ ಇತ್ತು. ಬೈಕ್ ಬುದ್ಧಿ ಹೊಡೆದಿದ್ದರಿಂದ ನನ್ನ ಎಡಗಾಲು ತೊಡೆಯಲ್ಲಿ ಮುರಿದಂತಾಗಿದ್ದು ಪೆಟ್ಟು ಬಿದ್ದು ರಕ್ತ ಗಾಯಗಳು. ಈ ಅಪಘಾತದಿಂದ ನನಗೆ ಪ್ರಜ್ಞೆ ಇತ್ತು. ರಸ್ತೆಯಲ್ಲಿ ನಡೆದುಕೊಂಡು ಹೋಗುವವರು ನನ್ನ ವೀರಭದ್ರಪ್ಪನಿಗೆ ವಿಚಾರ ತಿಳಿಸಿದ್ದು ಕೂಡಲೇ ನನ್ನ ಅಮ್ಮ ಆಂಬ್ಯುಲೆನ್ಸ್ಗೆ ಫೋನ್ ಮಾಡಿ ತಿಳಿಸಿದ್ದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ
No, he admitted that whatever given in that hospital is correct, not that complaint. In the evidence, he said whatever the statement given in that hospital is correct. Where is yes. This has been now that police has to say how they have come to the conclusion that this is not the vehicle when he has given a complaint to A vehicle. Why they have come to that B? Because he said that this is the vehicle. It is only the police who has subsequently has filed in a charge sheet and included that other vehicle. But charge sheet law finally in the vehicle. See, after that police has done all these acts, seizing of the vehicle is also different. Owner of that vehicle.
This 207 remove ಮಾಡಿದ್ನಾ? remove ಮಾಡಿ. This accident here, like inside button. ಹೌದು ನಾನು ಈ vehicle number but charge sheet ಆಗಿರೋದು ಕೇಸ್ ಆಗಿರೋದು
ಅಲ್ಲ ಈ ಓನರ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾನ ನಂದು ಆ ವೆಹಿಕಲ್ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿತ್ತು ಅಂತ. If he come before the tribunal said, ಅವ್ರು ಬರೋದೇ ಇಲ್ಲ.
That may not be the making of actually in the
ಓನರ್ ಬಂದ್ಬಿಟ್ಟು ನಂದು ವೆಹಿಕಲ್ ಇನ್ವಾಲ್ವ್ ಆಗಿತ್ತು ಹೌದು ಅಂತ ಒಪ್ಕೊಂಡಿದ್ರೆ ಇಟ್ ಇಸ್ ಡಿಫರೆಂಟ್.
cross-examination and harassing people now.
ಆಗಿದೆ ಸುಮಾರು ಕೇಸಸ್ ಅಲ್ಲ. ದೇರ್ ಇಸ್ ಅ ಫ್ರಾಡ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಟ್ ಪೊಲೀಸ್ ಅಡ್ವೊಕೇಟ್ಸ್. Only thing is that matter has to be sent it back to examine that police investigation officer.
He said, yes, sir. He documents basis.
No.
He has to be allowed. He has to pay. I can't want to be.
No. Then either see now that to accept your contention. Who is appearing for other side?
Rajesh, Vanita KR, Vishwanatha Pujari.
Let us see. Our regular MF. So yes, let us that if he agrees, then we can close that matter. Otherwise, we'll see what. Yes, that let us. Yes. Sorry.
Serial number 67, Salimullah Sharif for appellant, AK Bhatt, PI Sammati.
Yes, what is this, Mr. Sarmati? 2012 matter. Appellant counsel is absent last vacation. ಅಲ್ಲ ಈಗ contributory negligence 20% is on climatic 20%. Since you don't have any. Yes, our 20% I do. What is that other 80% on whom?
My vehicle.
Your vehicle. Huh? Offending vehicle. That your insurance company is there. Why that owner is necessary?
Insurance company always coupled with jointly and severally. Owner has to be represented or it has to be they have to seek for dispensation. In the absence of owner, only they become insurance company cannot be.
No, that insurance company tribunal has held that you are liable for 80%.
80%.
That can be done by recalling the that order and the dispensation. It's very easy. Salimullah Sharif. Pass or. 2012 matters. Yeah, no, otherwise purpose will serve.
20% liability, contributing negligence.
Our 20% agree ಮಾಡ್ಕೊಂಡ್ರೆ, you will not dispute that. Then he can file this thing if there is any enhancement, or we'll close that matter. If you met him, you just ask him to come. Yes. Yes, Mr. Double. This is vehicle damage. 16 days it was in that district. No, spares bus they have provided because of that meeting with an accident. Otherwise, not revenue loss. They are saying that since vehicle has kept for 16 days for a repair, for 16 days they are unable to run that vehicle. No, that cannot be. See, owner accident atkasna, owner insured, he having 2 cars, therefore he can use that other car. You cannot say that. You may not, that spare cars, spare vehicle car na bus na they can use for other route. Only thing is that whether they have proved that for any loss or not. Spare bus question barala. Yes, Mr. But ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಎಸ್ಟಿಮೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರಾ? ಇನ್ನೊಂದು 50% ಯಾರ ಮೇಲೆ? Who is negligent? 1 or 2 responsible pay 50%. Another 50% ಯಾರಿಗೆ? Owner of which vehicle? Your vehicle. ಅಲ್ಲ ಯಾಕೆ 50% ಓನರ್ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಕೇಳ್ತಾರೆ. ಅದಕ್ಕೆ 50% ಹೆಂಗ್ ಬರ್ತದೆ? ಆ ತರ ಹೆಂಗ್ ಬರ್ತದೆ? ನೆಗ್ಲಿಜೆನ್ಸ್ ಇಸ್ ಓನ್ಲಿ 1%. Either you have to be exonerated completely. ಅಲ್ಲ ನಿಮ್ದಲ್ಲ ಅವ್ರದ್ದು. KSRTC ಏನ್ ಡ್ಯಾಮೇಜ್? ಫ್ರಂಟ್ ಬಂಪರ್ ಹೆಡ್ಲೈಟ್ ಡ್ಯಾಮೇಜ್, ವಿಂಡ್ ಸ್ಕ್ರೀನ್ ಗ್ಲಾಸ್ ಬ್ರೋಕನ್. ಅಲ್ರಿ ವಿಂಡ್ ಸ್ಕ್ರೀನ್ ಗ್ಲಾಸ್ ಬಂಪರ್ ಎರಡು ರಿಪ್ಲೇಸ್ ಮಾಡ್ಬೇಕು. ಎಷ್ಟಾಗುತ್ತೆ? ಎಸ್ಟಿಮೇಷನ್ ಎಷ್ಟಾಗತ್ರಿ? Have you produced that estimation? Job card already. Where is that job card? Which is that exhibit? Huh? Have you examined anybody? Who is that? Huh? Already ಮೆಕ್ಯಾನಿಕ್ ಯಾರನ್ನಾರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀರ? ಮೆಕ್ಯಾನಿಕ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ. ಅವ್ನು ಜಾಬ್ ಕಾರ್ಡ್ ಬರ್ದಿದ್ ಯಾರು? ಅವ್ರಿಗೇನ್ ಗೊತ್ತಿರ್ತೈತ್ರಿ? ಜಾಬ್ ಕಾರ್ಡ್ ಬರ್ದಾರ ಎಷ್ಟು ಸೇ ಹೌ ಸಿ ಜಾಬ್ ಕಾರ್ಡ್ ಮೆಕ್ಯಾನಿಕ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಾರೆ. ಸಿ 20,000 ರೂಪಾಯಿ ಇದು ಎಲ್ಲ ಇದ್ರೆ ನೀವು 2 ದಿನದಲ್ಲಿ ರಿಪೇರಿ ಮಾಡ್ಬೋದು. 64,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿರೋದು 16 days. ಯಾಕೆ ಇಟ್ಕೊಂಡಿದ್ರಿ? ನಿಮ್ಗೆ ಯಾರು ಹೇಳಿದ್? ನೀವು ಕೆಲಸ ಮಾಡ್ದಾನೆ ಸುಮ್ಮನೆ ಇಟ್ಕೊಂಡಿದ್ರೆ? ವೇರ್ ಇಸ್ ದಟ್ ಯುವರ್ ಎವಿಡೆನ್ಸ್ ಮಿಸ್ಟರ್? See that evidence, Mr. We have to rely on that evidence only. We can't do anything. Petitioner is the owner of the bus, so and so, registered so and so. Bus was proceeding so and so. Front side, the asset is due to the said accident. Following items are damaged. Front side shape, highlight bumper, front windscreen glass broken. Front left side door damaged. At the time of the repairs, damages. ಎಲ್ಲಿ ಮಾಡಿಸಿರುವುದಿಲ್ಲ. ಡಿವಿಷನಲ್ ಮೆಕ್ಯಾನಿಕ್ಸ್
Either purchase ಮಾಡಿರೋ ಬಗ್ಗೆ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಾ ಅಂದ್ರೆ we don't have any document.
ನೀವ್ ಎಲ್ಲಿ ಹೇಳಿದೀರಾ ಇವೆಲ್ಲ ಮೆಟೀರಿಯಲ್ಸ್ ಅವೈಲೇಬಲ್ ವಿತ್ ಅಸ್ ಅಂತ? ಎಲ್ಲಿ ಹೇಳಿದೀರಾ ನಮ್ ಸ್ಟೋರ್ ರೂಮ್ ಅಲ್ಲೇ ಇದಾವೆ ಇವನ್ನೆಲ್ಲ ಅಂತ? ನಿಮ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ರಿಪೇರಿ ಪಾರ್ಟ್ಗಳ ಬದಲಾಯಿಸುವ ಡಿವಿಷನಲ್ ಮೆಕ್ಯಾನಿಕಲ್ ಇಂಜಿನಿಯರ್ ಎಂದು ನಮ್ಮ ಬಳಿ ಇದೆ ನಿಜ. ಡಿವಿಷನಲ್ ಮೆಕ್ಯಾನಿಕ್ ಇಂಜಿನಿಯರ್ ಬಸ್ನ ಡ್ಯಾಮೇಜ್ಗಳ ಬಗ್ಗೆ ಯಾವುದೇ ಸರ್ವೆಯನ್ನು ಮಾಡಿಸಿರುವುದಿಲ್ಲ ಅಂದ್ರೆ ನಿಜ. ಡಿವಿಷನಲ್ ಮೆಕ್ಯಾನಿಕ್ ಇಂಜಿನಿಯರ್ KSRTC ಯಾವುದೇ ಕೊಟೇಶನ್ ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ ನಿಜ. ಜಾಬ್ ಕಾರ್ಡ್ಗೆ ಸಹಿ ಇರುತ್ತದೆ. 41 ಹಣ ಮೆಕ್ಯಾನಿಕ್ ಪಾರ್ಟಿಗೆ ಖರ್ಚು ಮಾಡಿರುತ್ತವೆ ಎಂದು ಬೇರೆ ಕಡೆಯಿಂದ ಕೊಂಡುಕೊಂಡ ಬಗ್ಗೆ ಯಾವುದೇ ರಸೀದಿಗಳು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ಜಾಬ್ ಕಾರ್ಡಿನಲ್ಲಿ ಯಾವ ಪ್ರಮಾಣದ ಮೆಕ್ಯಾನಿಕ್ ಪಾರ್ಟ್ಸ್ ಗಳನ್ನು ಉಪಯೋಗಿಸುತ್ತೇವೆ, ದುರಸ್ತಿ ಕೊಟ್ಟಿರುತ್ತೇವೆ ಎಂದು ಇರುತ್ತದೆ. ಡ್ಯಾಮೇಜ್ಗಳ ಬಗ್ಗೆ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಸಾಕ್ಷಿ ಕೊಡಲು ನನಗೆ ಯಾವುದೇ ಅರ್ಹತೆ ಇರುವುದಿಲ್ಲ. ಸಾಕ್ಷಿ ಕೊಡಬೇಕಾಗುತ್ತದೆ, ಆದರೆ ಸರಿಯಲ್ಲ. ಅದೇನದು 41,821 ರೂಗಳನ್ನು ಮೆಕ್ಯಾನಿಕ್ ಪಾರ್ಟ್ಸ್ ಅದು. ಲೇಬರ್ ಚಾರ್ಜ್ ಬಗ್ಗೆ ಅಂತ ಏನು ಹೇಳಿಲ್ಲ ನೀವು. Where is the finding of the tribunal? It was included labor and material charges. They spent 41,000. Shows that items used for repairs. Only job card prepared by you. Person who has prepared the job card is not examined. ಎಲ್ಲಿ ಹೇಳಿದಾರೆ ಅವ್ರು 6 days ಅಂತ? ಒಂದ್ ದಿನಕ್ಕೆ ಎಷ್ಟು ಅಂತ ಲಾಸ್ ಹಾಕಿದಾರೆ ಅವ್ರು? 16 days 4 8 Bus was average earning is taken at 4,000. Bus was
rewritten in the red ink. There was no signature for retracting corrections. Change ಮಾಡಿ ಅದಕ್ಕೋಸ್ಕರ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Yes, that's all.
Alteration ಮಾಡಿರೋದು signature ಇದೆ. Conclusion, mechanical example, what expected
Yes, 55,000 ಆಗುತ್ತೆ. Out of 84,000 ಇದೆ 85,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Is it not? 84,000. It comes to 55,000. Why? Where is that finding? Pay and recovery ಆದ್ರೆ ನೀವ್ ಯಾಕೆ ಮತ್ತೆ ಇಷ್ಟೊಂದು ಗಲಾಟೆ ಮಾಡ್ತೀರಿ? Then it ultimately owner has to pay. Where is that pay and recovery? Lorry was not at all produced in this case. The above said reason this court is of the conclusion that are responsible to pay 50%. Who has 1 and 2? Already 1 and 2 50% ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇನ್ನೊಂದು 50% ಯಾರಿಗೆ? ಆ ತರ ಹೇಳಿಲ್ರಿ ಅವ್ರಿಗೆ. ಪ್ಯಾರಾ 19 ಹೋದ್ರಿ ರೀ. ಲಯಬಿಲಿಟಿ ಆನ್ ದಟ್ 50% ನಿಮ್ಮ ಮೇಲೆ ಇರೋದು. ಪ್ಯಾರಾ 19 ಅಲ್ಲಿ ಇನ್ನೊಂದು 50% ಯಾರಿಗ್ರಿ? ಎಲ್ಲ ಐತಿ ತೋರಿಸಿ. let him show that. Para 19. Or each 1 and 2 are responsible for pay of 50. One and 2 are responsible for payment of each. Another 50%. Now you are saying that have you taken that contention? Pay and recovery. The DL of the driver of the bus as well as the lorry was not at all produced in this case. For the above said reason, this court is up. Already DL of the driver of the bus as well as lorry. Allah, but negligence is only on that lorry, driver of the lorry. Now, whatever the thing, even assuming that the driver of the bus is not having a DL, since you are in a negligent, Supreme Court said that not because having in a DL is not in a liability to pay that compensation. Yes. No, you are challenging that also 50%. Then we'll see that records 230 will see.
Your Lordship, please, my lord.
Yes.
Serial number 63, my lord.
63.
Yes.
63 pass over.
It was disposed on 12/10/2013, my lord.
Illa the being spoken to recall agide agi. In fact, this appeal is not clubbed along with that appeal.
ನನಗೆ ನೋಟಿಸೇ ಇಲ್ಲ.
Yes.
Papers will, I have to get the papers, my lord.
No, I think we'll see. Even that counsel is not appearing. If he is not appearing, I will fix the date and dismiss for default. What to do? 2011 matter.
Please.
Let us see that process.
Serial number 69, my lord.
Yes.
I am appearing for the appellant.
Yes.
Sripas Shastri ಇನ್ನೊಂದು ಮಧ್ಯಾಹ್ನ ಇನ್ಕನ್ವೀನಿಯಂಟ್ ಅಂತ ಅಂದ್ರು. Saturday
ಶನಿವಾರ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ, ನಂದೇನು ಆತರ ಏನಿಲ್ಲ.
ಇಲ್ಲ ತೊಂದ್ರೆ ಇಲ್ಲ.
Saturday.
Sir,
Monday. She wants Monday.
much.
Yes. Third list 2:30. Third list ಅಲ್ಲಿ ಏನಿದೆ? Oh, which matter? Third list you are not there. Shivanand Law Associates, you are appearing. Oh, Krishna Swami, you are appearing for whom? Yes, he is ready. Yes, 2:30. Yes.
Hello. ಹೇಳಿ. ನಾವೇನ್ ಮಾಡ್ತೀವಿ?
ಇದೊಂದು ಚೇಂಬರ್ ಕೊಟ್ಬಿಡಪ್ಪ. ಚೇಂಬರ್ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ವಿ.
Court officer? Hello, court officer? Court officer? Court officer?
ಹೇಳಿ ಸರ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 45 ಏನಾಯ್ತು ಸರ್?
ಯಾವುದು?
45.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಹಲೋ ಹಲೋ, ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಪುಟ? 1 ಗಂಟೆ ಆಯ್ತಾ? ಈಗ ಎಲ್ಲಿದ್ದೀರಿ? ಆಯ್ತು ಆಯ್ತು. ದಾರಿಗೆ ಒಂದ್ ಕಡೆಗೆ ನಿಲ್ಲಿಸಿ ಟೀ ಕುಡಿಬೇಕು, ಒಂದ್ ಕಡೆಗೆ ನಿಲ್ಲಿಸಿ ಎಳೆ ಕುಡಿಬೇಕು, ಒಂದ್ ಕಡೆಗೆ ನಿಲ್ಲಿಸಿ ಟಿಫನ್ ಮಾಡ್ಬೇಕು, ಆಮೇಲೆ ಲಾಸ್ಟ್ಗೆ ಒಂದ್ ಕಡೆ ನಿಲ್ಲಿಸ್ಬಿಟ್ಟು ಇನ್ನೊಂದ್ಸಲ ಎಳೆ ಕುಡಿಬೇಕು. 4 ಕಡೆ ನಿಲ್ಲಿಸ್ಕೊಂಡ್ಬಿಟ್ಟು ನಿಧಾನಕ್ಕೆ ಬರ್ರಿ. ಹ್ಮ್ ಬಾಯ್ ಪುಟ್ಟ.
ಊಟ ಜಾಸ್ತಿ ಆಯ್ತಾ ಏನು? ನಾಗರಾಜ್
Your Lordship, one submission, my lord. Serial number 67, my lord. Kalimula Sharif for ಸಿಗ್ಲಿಲ್ಲ ಫೋನ್ ಮಾಡಿದ್ರು. ಅದಕ್ಕೆ ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ. ಫರ್ದರ್ ರೀಡಿಂಗ್ ಅಂದ್ರೆ ಅವಾಗ ಬರ್ತಾರೆ.
Tomorrow.
Much obliged, my lord.
Yes, ಕೊಡಿ record ಕೊಡಿ. Where is that? No, he is saying that regarding that negligence. No, whether you are arguing on the point of negligence. Then yeah, that I will consider. Which is that judgment? ಆಯ್ತು, ಎರಡು ನೋಡೋಣ.
Number 70, C.G. Raju for appellate, connected matter.
Yes, Mr. Raj. Asor.
Number 71, Nirmala K. Nagaraja for appellate.
Yes. Asor. List number 3.
Number 3.
Melody. I appear for the appellant KSRTC.
Yes.
Melody, the tribunal awarded compensation of rupees 50,000 with 9% interest. Melody, I have challenged both on the ground of negligence and quantum. Personally, Melody, both are against me. Not on record.
Yes.
Motion is concerned, Melody, it may be 6%.
Yes.
Negligence and quantum, both.
Yes. Yes. Sri.
While getting down from the bus.
Yes. Yes.
She fell down and
Yes.
sustained injuries, for which
Yes.
I am not liable to pay the compensation.
Have you examined any witness?
I have not examined any witness.
Yes, Sri
Driver.
Nagaraj. Here Nagaraj, Learned Counsel appearing for the claimant has the corporation has contended that the accident is occurred due to rash and negligent, due to the negligence of claimant himself.
Well,
the tribunal is error in held that driver of the bus is negligent in causing that accident. He contended that the claimant, while getting down from the bus, she fell down and suffered injury. Therefore, the driver of the bus is not negligent in causing that any accident. The tribunal error in fastening the liability on the corporation. In respect of quantum, he has contended that considering that injury suffered by the claimant and considering the age and avocation, the compensation awarded by the tribunal is on higher side. Lastly, he has contended that in view of judgment of this court, the interest awarded by the tribunal is on higher side, which is sought for allowing that appeal filed by the corporation. Respondent served unrepresented. Heard the learned counsel for the parties. Arose judgment and award. The case of the claimant that on 25/11/2016 at about 3:42 p.m. the petitioner was traveling towards Hirekerur to Haveri by KSRTC bus, registration number KA42F439. When the said bus was reached near KSRTC bus stand, all the passengers were left on while the petitioner was trying to left down. The driver of the KSRTC bus, without giving any signal, suddenly moved the bus. Due to that, the claimant fell down and suffered injury. To prove her case, she has examined herself as PW1 and examined 2 witnesses as PW2 and 3, has produced 16 documents. In her evidence, she has reiterated the statement made in claim petition. To disprove the claim of the, and she has produced FIR, complaint and charge sheet, Panchanama and wound certificate. To disprove the case of the claimant, respondent has not examined any witnesses.
Driver examine.
Huh?
Driver.
Except examining the driver. She has produced so and so documents. In her exam, to disprove the same, in her cross-examination, nothing worthwhile has been elicited to disprove the case of the petitioner. Considering that evidence of the parties and material available on record, the tribunal has rightly fastened the liability and rightly held that the driver of the bus alone is negligent in causing the accident. In respect of quantum, considering that injury suffered by the claimant, considering that wound certificate exhibit P7, the tribunal has awarded just and reasonable compensation of rupees 50,000. In respect of interest, in view of judgment of this court in so and so, the interest awarded by the tribunal has to be scaled down to 6%. To that effect, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as
Amount in deposit may be transferred to the.
Amount in deposit is transferred to the tribunal.
My name may kindly be. My name.
Yes, office. Yes. Office is directed to delete the name of yes, Nirmala.
Please.
Nagaraj Aperi. Yes.
Number 3, program number 13 matters for order, serial number 1, Janardhan Reddy for appellate, A.R. Ramesh.
This court by order dated 26/9/2022 has permitted the appellant to take out notice to respondent number 2 and 3 through paper publication. Accordingly, the memo is filed along with the paper publication. Respondent number 2 and 3.
Respondent number 2, P.R. Raghavendra. Respondent number 3, Abdul Rahman.
Called, none appear. Memo is accepted. Service of notice to R2 and R3 held sufficient.
Admission matter, serial number 2, Sivananda S for appellate, connected matter, Ananda Shetty A.
Yes. At the request of the parties, refer this matter to Lokadala. None appear. Release this matter. 2 weeks. Huh? Yes. In 17 or 16? 17 and 11,000 ಇದೆ 50% ತಾಂಡಿದೆ. $3703. Which page? Yes. Future prospects ತಾಂಡಿದಾರಾ? ತಾಂಡಿಲ್ವಾ? Application waiting. That's all. Well, liability and dispute ಇದೆಯಲ್ಲ. Notice to R1 is dispensed 51 days delays control. Yeah. Claimant has contended that at the time of the accident, deceased was earning 16,500 per month as a carpenter. The tribunal has assessed the notional income of the claimant as 9,000. The notional income of the deceased as 9,000 per month is on lower side. He further contended that in view of judgment of apex court in case of procedural, the claimants are entitled for future prospects. Lastly, he has contended that in view of judgment of apex court in case of Burma, the claimants are entitled 44,000 each. Hence, he sought for enhancement of compensation. For contra, Shruti Geeta Raj, Learned Counsel appearing for the insurance company, has contended that even though the claimants have claimed that deceased was earning 16,500 per month, they have not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the deceased as 9,000 per month. She further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, she sought for dismissal of the appeal. Heard the learned counsel for the parties peruse judgment and award. It is not in dispute. What is the name of the deceased, Mr. Anand? 302 na 4 702 703. Huh? 3703 Nagaratna Re. Yeah, which is that appeal, Mr. Nagaratna is that appellant. Other appellant are Nagaratna. Yes. Yes, yes. What is the name of the deceased? This Ramesh, Allah? Yes. It is not in dispute. Ramesh died in road traffic accident occurred on 19/6/2017 due to rash and negligent driving of driver of car bearing registration number KA02 EIF 9077. Even though the claimants have claimed that deceased was earning 16,500 per month, they have not produced any document to establish the same. Under that circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, the notional income has to be considered as 11,000. In view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Deceased is a bachelor the 50% of the income of the deceased has to be deducted for personal expenses. At the time of the accident, he was aged about 22 years. The multiplier applicable to that age group which is 18. 18. Accordingly, loss of dependency has been reassessed as follows. 7,000 plus 4,400 at the rate of 40%, 15,400 minus 7,700 at the rate of 50%, 7,700. 7,700 into 12 into 18, 16,63,200. In addition, 16,500 for loss of estate, 16,500 for funeral expenses. In view of judgment of apex court in case of magma. Your parents are. The claimant number 1 is entitled 44,000 for penile consortium. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Insurance company is directed to deposit compensation amount with interest within 6 weeks from date of receipt of copy of the summons.
Delay dispensed.
Yes, delay condone, notice dispensed.
23, yes, Girish for appellant, B.R. Sundar Raju.
Yes. Ready? Serial number 23. Yes. Ready? Yes. 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 Disability assessed by the doctor. Yes. Yes. Treated. In fact, even judgment of that, even English and other US courts, doctor who has treated, he is biased in giving an evidence. One should be a doctor who is not a treated has to be examined and given evidence. Doctor who has treated, he will not say that my treatment is not correct before disability is 18%. Only thing is, doctor should see that patient and he should assess. If it is an orthopedic, should be an orthopedic surgeon. Orthopedic surgeon cannot say about the neurosurgeon. That is what that we have to see. No, in here, even though doctor who has treated, he knows that patient is well recovered. Still, they are saying that here he is 80% disabled. Now it is reverse. But anyhow, that we will see that. Yes. See, that is why I said your doctor who has treated, he has treated well, patient has fully recovered. Still, he is saying that he is not recovered. Here it is a reverse. No, the main thing is how you will cross-examine the doctor. You have to initiate it from the. That is how that we have to see that evidence. That is what. Now, where is that doctor said doctor evidence again? How much he said the limb disability?
Harmless degraded is 10%.
10%, yes.
But the natural human behavior, when you see that.
Yes.
Wait, the things that. If the fracture is imagined to be and not able to be doctor, he has.
It is more than permanent disability. There is the evidence. The date of the speech that is not treated doctor.
And he is 21 years old, so the
Yes.
the process of recovery is much faster when the patient is younger.
Yes, yes, that is there. What is that income? How much you have claimed? Huh? Claim is 15,000. What is the date of the accident? 2015. $9,000. How many days you are in the hospital? So, loss of earning during the treatment. Loss of future earning account of permanent disability. Future medical expenses, damages, pain. Loss of immunities. What is that interest awarded?
9%.
Yes. Yes, that's all. Yes, Girish, learned counsel appearing for. The claimant has contended that due to that extent, the claimant has suffered grievous injury. He has examined the doctor Nagaraj BNS PW2. In his evidence, he has deposed that the claimant has suffered 41% limb disability, 13.6% to the whole body. The tribunal has assessed whole body disability is 10% is on lower side. He further contended that at the time of the accident, the claimant was earning 15,000 per month. The tribunal has assessed the whole body, the tribunal has assessed the notional income of the claimant as 7,000 per month is on lower side. He further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 21 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri P.D. Raju, learned counsel appearing for the insurance company, has contended that even though doctor has assessed whole body disability is 13.6%, he is not a treated doctor. The fractures are reunited, and the claimant was aged about 21 years at the time of the accident. Considering this age and injury suffered by the claimant, the tribunal has rightly assessed the whole body disabilities 10%. Further contended that even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. In other circumstances, the tribunal has rightly assessed the notional income of the claimant as 7,000 per month. Lastly, he has contended that considering that evidence side. Hence, he sought for dismissal of the appeal. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on in 444. Due to that extent, the claim in his evidence, he has deposed that the claimant has suffered produced any document to establish the legal service authority for the accident occurred in 2015. Accordingly, loss of future due to that extent, the claimant has suffered the aforesaid injury. He was inpatient for a period of 21 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, I am inclined to enhance the compensation for loss of amenities from 25,000 to 40,000. Loss of income during the later period is granted for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. The enhanced compensation amount carries 6% interest. At the monthly income just yes. Delay 14 days control. Yes.
13.6%.
Yes.
Serial number 37. Arun Kunnappa for appellate.
Yes. 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 What is this, Mr. Yes. Yes.
The claimant is suing the petition is suing them. And the respondent is only national. The owner of the car has not been made a party. So the law is, unless and until the thought leader is made a party.
Yes. 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 You are only indemnifying that. But you have to make him as a response.
Unless the insured is made liable, the insurer is not liable.
No, that you are that owner. No, see, he is claiming that PA coverage. No, that's you cannot claim that compensation on behalf of that. That is what that. PA coverage is entitled.
That is not under the motor vehicle side. Whatever the contract between the insurer, that is entitled, not under the motor vehicle side.
What is that award amount awarded? No, that can be claimed under that Insurance Motor Vehicles Act also. PA coverage will be awarded under that.
This is an award under section under 166.
Yes. Sorry.
This is award under 166.
Motor Vehicles Act.
And
Yes.
fantasy judgment, the claim under 166 is indemnified under section 147. So this is a claim between 166 and 156 is not entitled. Is only entitled under the contractual liability of 2 lakhs, and that too, that shall not carry the interest.
Yes, let us.
That
No, in so many cases, compensation has been awarded, even Supreme Court, PA coverage under Motor Vehicles Act itself.
First and foremost, there is no liability concept against the insured. There is no liability concept against the insured only indemnifies. That way itself is not maintained, very honest.
What is this judgment?
The applicant challenged the rate award of the tribunal. Both the High Court mainly contended that this himself was the co-owner from driver of the applicant vehicle. It is not a part, third party within the meaning to owner requirement engaged. The accident occurred due to the negligence of the vehicle. Therefore, the applicant, being the insurer of the vehicle, was not liable to pay the compensation. Philosophy for fifth paragraph there. As it has been established, the payment is for the premium or paid by the person. The insurance company is liable to pay the system, even though it is limited to that to the claimant response. There is no sudden effect against the determination of comfort. So finally, at paragraph 9, therefore, the High Court was not justifiably directing the applicant to pay the compensation as determined. Since the indemnity is extended to personal liability, this is limited to 2 lakh under the contract application. Respondent is entitled for the said amount towards compensation. Hence, against the complaint is directed before the.
Yes, here that concession has been considered.
One more thing. Can you see that?
No. We'll come to that later. Whether application under 166 is maintainable or not. That is the issue. They said, even though it is a contractual liability, the Supreme Court said, this is what the Supreme Court judgment.
I have this Verma, this Karuja, and this AP Mitra. This is already something which is very clearly says.
No, this is 2018. This is 2018. Right.
The top visa has to be liable first. Unless the top visa is liable.
Yes.
The insurance company is not become liable.
Yes.
And moreover, even to claim under
Challenging the judgment award of the so motor accident, first respondent motor vehicle, so second respondent is the wife, the mother of the deceased. I find the response here, the children.
That's it. Party is the meaning of act. This is the making of the own action of back to engine driving. Here in this case,
himself cannot file a claim. Distinguish now saying that whether he is an inmate or driving or not. You are claiming that this is in between that contract between that owner, all that comprehensive policy, it is not mandatory under that Motor Vehicles Act. This is a contract between the party. In that also it is maintainable. That's what the now will. No, this is also under 166. What you say about this judgment, I am asking. Yes. Yes, you verify this judgment, we'll also see next week. But that is the only point. Has been, yes. 2020 or recent. Appeal is filed with the insurer challenging judgment award. The fact matters the petitioner was proceeding on the Hero Honda. No, this is this has been considered by this court. I can't take any different view. See that latest judgment of this court. Single judge has considered. Yes, I will grant time next week. No problem. Yes. Yadralli. No. His main contention. No, I am not on that. Yeah, no, this is the case which is decided. Know that I asked him to ask Supreme Court judgment. It is binding on me. It is next week and the next Guruvara. Yes. Either number. Harshit, put it. Matter is called in first round. Yes, Mr. Venkatesh. Yes, Mr. Lakshmi Narasimha.
Swami, the insurance company appeal, my lord, 163 is not maintainable. Since
Yes,
the
yes.
deceased salary was about 10,000 rupees per
Yes.
month, as proved by examining the officer of the Leo housing employer. My lord, please come to the second para of learned MSCT judgment, para number 2, my lord.
Yes.
At page number 3. It is contained that deceased Shambhu Shettikar was 34 years old at the time of occurrence of the accident. He was working as a driver cum office assistant at Leo Chartered Housing Private Limited, drawing a salary of rupees 10,000 per month. But however, petitioner have restricted the salary of income of this to extent of 3,300 per month.
Yes.
Please come to next, my lord. Para 16. Page 14, para 12, my lord.
Yes.
This deceased Shambhu Shettikar was working as a driver cum office assistant of Chartered Housing Private Limited, Victoria at Bangalore. He was drawing consulted salary of rupees 10,000 per month. But para 12, my lord, page 14.
Yes.
But however, as this claim is on a no fault liability basis, that is under 163A of the MV Act, petitioner restricted their salary of income of deceased to an extent of 3,300 per month. Next, last two lines, my lord. The PW2, namely Leo Lewis, son of late Anthony Lewis, has deposed that he is working as a general manager, admin and finance in Chartered Leo Housing Limited Company, Bangalore, and he is authorized to depose in this case on behalf of the company. Such authorization letter is produced at market exhibit P18. His job identity card is produced at market P19. PW2 general manager has categorically stated that the deceased Shambhu Shettikar was working as an office assistant cum driver with effect from 1st April 1996. In their company, he was drawing consultant salary rupees 10,000 per month.
How much he is set up to 3,300?
Now they have restricted their income, my lord. Though he was drawing 10,000 rupees per month.
Yes, who is for other side?
MS Narayan, PM Subramani, K. Vishwanath.
Ramachandra for 1 to 3, Allah. Yes. 3. Lakshmi Narasimha, learned counsel appearing for. The insurance company has contended that the claim petition is filed under. No, that one judgment is there. It can be converted as an 166 and proceed further.
My lord, I will take my last to the judgment of the Supreme Court.
Now, Supreme Court said liberty can be reserved to file an appeal under 166. You can file under 166.
Deepal Girish by Soninale, para 51 Tavalima, 2004 AC full bench judgment, 2004 ACJ 934. Para 51 Bani Sometama Page number
51, yes.
My lord. The scheme is envisaged under 763A in our opinion, leaves no manner of doubt by reason thereof, the rights and obligations of the parties are to be determined finally. The amount of compensation payable under the above said provisions is not to be altered or varied in any other proceedings. It does not contain any provision providing for set off against higher compensation, unlike section 140. In terms of the said provision, a distinct and specified class of citizens, namely the persons whose income per annum is rupees 40,000 or less, is covered thereunder, whereas section 140, 160, that is a different issue, my lord. So unless yes,
no, that is true. But he has a liberty to file an application under 166.
No, when the income is proved by the employer, that
No. He can
rupees.
no, he can file a claim petition under 166 to show prove that negligence.
My lord, at the same judgment, come to para 67. How the learned Supreme Court, Honorable Supreme Court, taken into consideration of the Codella case also.
Para
66.
Yes.
We may notice that section 167 of the Act provides that death or bodily injury to any person gives rise to a claim compensation under the Act. And also known as that is workman compensation. The Motorway Act contains different expressions. As for example, under the provisions of the Act, under any other provisions of the Act, or any other law or otherwise. In section 163A, the expression notwithstanding anything contained in this Act or any other law for time in force has been used, which goes to show that Parliament intended to insert non-obstance clause of wide nature, which would mean that provisions of 168 would apply despite the contrary provisions existing in the said Act or any other law for the time in force. Section 163A of the Act covers cases where even negligence is on the part of the victim. It is by way of exception to section 166, the concept of social justice has been duly taken care of. We therefore are of the opinion that Codella case 2001 ACC 827 SC has correctly been decided. However, we do not agree with the findings of the Codella that if a person invokes provisions of 163A, annulment of parties is treated as a cap. In our opinion, the proceeding under section 163A being a social security provision, providing for a distance scheme, only those whose annual income is up to ₹4 can take up a bit thereof. This is the finding given by the full bench of the Supreme Court, my lord. All other claims are required to be determined under chapter 12 of the Act. This is the finding of the Honorable Supreme Court, my lord. And there are certain judgments of this court, division bench of this court, where a claimant whose income is more than 40,000 cannot restrict to come under 163A. And as far as judgment of our court is concerned, my lord, one is a single judge bench justice by Jagannathan in MFA 14708 of 2007 MBC, and latest one of this court, para 6 of the judgment in MFA 6575 of 13 decided on 8 June 2021 by Justice Sandesh, my lord, at para 6. And even that case, the full bench judgment of this court is also quoted by the Honorable Justice H.B. Sandesh, my lord, in June 2021 judgment. If my lords permit, I read that para number 6 of the judgment of this court, my lord, citing the full bench judgment in Omana Chetan versus OIC of this court, my lord. Para 6, if I am permitted to read, my lord. Am I audible, my lord?
ಸರ್ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ.
Which is the paragraph you read, mister?
Para 6, my lord.
No, in that, no, full bench judgment, Supreme Court.
Full bench ಅಲ್ಲ ಸೌಮ್ಯ, ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್. ಫುಲ್ ಬೆಂಚ್ ಅಲ್ಲ ಅದು. ಫುಲ್ ಬೆಂಚ್
Supreme Court.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದೇ. ಸುಪ್ರೀಂ
ಅದೇ
ಕೋರ್ಟ್
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಪ್ಪ?
ಪ್ಯಾರಾಗ್ರಾಫ್ ಫುಲ್ ಬೆಂಚ್ ಇದೆ ಹೇಳ್ತೀನಿ. ಫುಲ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪ್ಯಾರಾ 51, ಮೈ ಲಾರ್ಡ್. 51-67.
ಪ್ಯಾರಾಗ್ರಾಫ್ 51.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಮತ್ತೆ 67 ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ. In view of the above, the claim petition filed by the claimant under section 163A of the Motor Vehicles Act is not maintainable. Accordingly, the appeal is allowed. Judgment and award passed by the tribunal is set aside. Amount in deposit is transferred to the tribunal.
To the appellant, my lord. ನಮಗ್ ಕೊಡ್ಬೇಕು ಸರ್, ನಮ್ ದುಡ್ಡು ತಮ್ಮ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಪ್ರಕಾರ ಕಟ್ಟಿರೋದು.
ಅಲ್ಲ, ಎಲ್ಲಿ ಕಟ್ಟಿದ್ದೀರಾ?
ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಇವರು MACT ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ.
The tribunal is directed to refund that amount in deposit in favor of the appellant after the verification.
My name is shown as appearing for the appellant.
Yes.
Please, ma'am. Okay.
ಸುಭಾಷ್ ಅಂಡ್ ರಾಜೇಶ್, ವನಿತಾ, ವಿಶ್ವನಾಥ ಪೂಜಾರಿ.
ಅದೇನೋ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂತೀವಿ ಅಂತಂದ್ರಲ್ಲ ಎಲ್ಲಿ? ಅಲ್ಲ, ಅದೇ ಅವ್ರ ಹತ್ರ ಮಾತಾಡಿ ಏನೋ ಹೇಳ್ತೀನಿ ಅಂತ ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು. ಹೌದಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್.
68 ಸಿಟಿ ಶಿವಣ್ಣಗೌಡ, ಕಬ್ಬಾಲಿ.
When do you want? Next. Tomorrow. Day after tomorrow. Yes.
70 PB Raju for appellant.
Yes, ಅವ್ರು ಯಾರು appear ಆದ್ರಲ್ಲ ರಾಜ್. Yes, ಕೊಡಿ ಅದನ್ನ.
14.
Madam. Just verify regarding that. Number 166. You were there, no, that time. Any judgment? Let's extra put. Own certificate exhibit P6 for. None appear. Deal with this matter next week. Stay.
ನಾವೇನಾದ್ರು ಇನ್ವಾಲ್ವ್ ಆಗ್ತದೆ ಎಲ್ಲ ಎಲೆಕ್ಟ್ರಿಕ್ ಕಷ್ಟ ಅದಕ್ಕೆ ನಾವು ಇನ್ವಾಲ್ವ್ ದಿನ ನಾವು ವಾಟ್ಸಪ್ ಓಪನ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಸ್ವಲ್ಪ ಅದೇ ನಮಗೆ ಪ್ರೆಜರ್ ಹಾಕಿ ಪಾಪ ಆ ಕೇಸ್ ನಮ್ಮ ಕೇಸ್ ಆದ್ರೆ ಬರುತ್ತಾ ಇಲ್ವಾ ಅಂತ ನಂಬರು 1107 ಇದೆ ನೋಡಿ. ಇದರಲ್ಲಿ ಇರ್ಬೋದು ಅದರಲ್ಲೇ ನಿಮ್ಮ ಹತ್ರನೇ ಇದೆ 1107. ಏನಾಯ್ತು ನೋಡಿ ಇಲ್ಲಿದೆ ಇಲ್ಲಿದೆ ಒಂದು ಡೇಟ್ ಮಾಡಿ ಅಪ್ಲೋಡ್ಗೆ ತರ್ಬೇಕು ಇವಾಗ ಸೈನ್ ಆಗಬೇಕು. ತಪ್ಪಾಗುತ್ತೆ. ಅಪ್ಲೋಡ ಮೇಡಮ್ ಎಲ್ಲ ಆರ್ಟ್ ಶೀಟ್ ಬರೆದ್ರಲ್ಲ ಅವರು ಊಟ ಪಟ್ಟಿಲ್ಲ ಇಲ್ಲ ನಾನು ಊಟ ಬೇಕಾಗ್ತಿದ್ದೀನಿ ಅಲ್ಲ ಅಲ್ಲ ಕೆಳಗಿಲ್ಲ ಮೇಲೆ ಮಾಡಿದ್ದೀನಿ ಮೇಲೆ ಕೆಳಗೆ ಮಾಡ್ತೀನಿ. ಕೆಳಗೆ ಮಾಡ್ತಾ ಆಯ್ತಾ.